Good afternoon. This is a meeting of the Licensing Subcommittee. The meeting is to be adjourned as not all members of the committee are present as yet, as one has had to tender apologies and we're waiting for the reserve to arrive. The anticipated start of the meeting will be at 12:30. The meeting is now live.
Thank you for that, Karen. Welcome, everyone. I am Councillor Scott Pater Harris. I just want to go through a few bits of housekeeping as we begin. Please be assured that we have appropriate cleansing and social distancing measures in place to ensure that this meeting is undertaken in a COVID-secure manner. Public seating has been made available, and this meeting is also being webcast to allow the public to review remotely if they so wish. The public seating area is not in view of the camera used to webcast this meeting. Just a small bit of housekeeping and safety information. If the continuous fire alarm sounds, please evacuate the room and public gallery by the stairwells. Do not attempt to use the lifts. Please assemble at the Queen Victoria statue in the Guildhall Square. In order to comply with the Guildhall Trust Fire Marshal regulations, anyone who signed in at the Guildhall reception desk should sign out when leaving the building at the end of today's meeting. Live web streaming. Just going to draw everyone's attention to the fact that the meeting is going to be live streamed, so everyone speaking will be on camera. Members of the press and public are also permitted to record the meeting on the understanding that it neither disrupts the meeting nor records those stating explicitly they do not wish to be recorded. And also, can everyone please use their microphones in front of them, and remember to switch them off when they're finished. It's quite simple, just press the button and the red light will come on, and then you can speak through your microphone. Well, I obviously have introduced myself as Councillor Scott Pater Harris, so I'm just going to literally go to my left and allow everyone to introduce themselves, and we'll open the meeting formally.
Good afternoon, I'm Councillor Benedict Swan for Cotton and Anchorage Park Ward, and thank you all for your patience to allow me to be here this afternoon.
Good afternoon, my name is Ben Attrell. I'm a solicitor employed by the Council and I'll be advising the subcommittee this afternoon. Thank you.
Good afternoon, Derek Stone. I'm the Principal Licensing Officer, and sat alongside me is Grace, who is a colleague in our office, just here as an observer.
Good morning, my name is Immigration Officer David Newcomb.
I'm John Walsgrove and I'm the solicitor for Mr Choi, and this is Mr Choi sat next to me.
Sorry, Acting Police Sergeant Pete Rackham, representing the Chief Officer of Police for Hampshire Constabulary.
Good afternoon, PC Peter Vincent, also with Hampshire Police Licensing Team, representing the Chief Officer of Hampshire Constabulary.
And I'm Councillor Magic of the Paulsgrove Ward.
Thank you. That is everyone has been introduced. I will remember it's Acting Police Sergeant, so I always get that incorrect, so sorry about that. Appointment of Chair. Do we have anyone to propose and second the Chair?
I would propose you, Councillor Harris.
I second you, Councillor Harris.
Thank you. That's the Chair dealt with. Do we have any apologies?
Councillor Tom Coles sent his apologies, and hence Councillor Swan is here as his reserve.
Do members have any declarations of interest? I mean, I'm going to declare an interest that's not a prejudicial one or a pecuniary one that's going to cause me any problems. There has been a representation from a member of my group that is on there, from Councillor Lee Mason, so I'm just going to declare that. Just for openness and transparency, we haven't discussed the application at all. And there's also another representation from a member of the licensed trade that I know, which is a Mr Hudson, through obviously this committee and through various other avenues I've had to deal with him before. So on that basis, again, we haven't discussed it and I haven't even heard any representation, so I'm just going to be open there. Does anyone else have anything they want to add? Brilliant, thank you.
Can I just double check, no financial ties or any other links with Mr Hudson?
No, absolutely not, just somebody I know through doing this.
Fine.
And now we move on to the item that we're here for, which is item 4, which is Licensing Act 2003 review application, Noble House Restaurant, 43 Osborne Road, Southsea, PO5 3LS. Obviously, we're here to consider and determine a review application pursuant to Section 52 of the Licensing Act in respect of the following premises, which is Noble House. And obviously, this subcommittee has been requested to determine the matter. So what I'm going to do now is I'm going to move on to the licensing officer to outline the application and any relevant representations or highlight any points relevant to the licensing authority statement of licensing policy and statutory guidance. Over to yourself.
Thank you, Chair, and good afternoon, members. Thank you for introducing that. So we're here today following a review application, and the grounds for the review are attached as Appendix A in my report. It's been submitted by the Home Office Immigration Enforcement Team and relates to the prevention of crime licensing objective. This follows a visit to the premises by Home Office immigration officers at 20:30 hours on Saturday 23rd of October 21, where they found 3 illegal workers working and living on the premises. On entry to the premises licence holder, Mr. Choi, was reported to be obstructive towards the officers. Statements submitted as part of the review detail Mr. Choi's behaviour and how obstructive he was, not only physically trying to prevent access, but giving verbal directions in his foreign tongue to staff present who initially refused to engage with the immigration officers. David Newcomb, who was the lead immigration officer for this visit, is present today and will go into more detail regarding the visit and what was found. Attached to Appendix B is the Home Office Premises Licence Review Pack, together with 4 statements from the immigration officers who attended the premises, and also the interviews undertaken on the night with Mr. Choi and the 3 illegal workers. A copy of the current premises licence is attached to Appendix C, and for your information, Mr. Choi has been the licence holder for a number of years, and he was certainly the licence holder before the transition to the Licensing Act of 2005. In accordance with the Act and prescribed regulations, public notice of the review application was given both at the premises and also at the civic offices. In addition, a notice of the review application was also posted on the council website. The review application was also served on responsible authorities, and as a result, PC Vincent, on behalf of the Chief Officer of Police for Hampshire Constabulary, submitted a representation supporting the review, also on the grounds of the prevention of crime and disorder, seeking revocation of the premises licence based on the seriousness of the offence and previous history. PC Vincent and Acting Sergeant Rackham are the Portsmouth-based licensing officers, and they're both present here today to address you. We received 10 support representations in relation to Mr. Choi. All these representations are attached to Appendix D in your bundle. And at Appendix E, there's an email clarifying the first date in the Home Office review bundle at paragraph 2.9, which should read 23rd of the 9th, 2011, and not 2012 as stated. Members, when determining this review, you must have regard to the promotion of the licensing objectives, which, as you know, are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. I have set out in my report at page 4 of your bundle the other policy and statutory considerations which you are all familiar with. The statutory guidance issued by the Home Secretary in accordance with Section 182 of the Licensing Act 2003 at paragraph 11 clearly sets out the review process, and I've set out in my report what I consider relevant for this hearing. Paragraph 11.19 states, if you consider that action is appropriate under your statutory powers, you have set out at the bottom of page 5 in your bundle what steps you can take in this case, the ultimate sanction being the revocation of the premises licence. Paragraph 11.26 of the guidance states, where a licensing authority is conducting a review on the grounds that the premises have been used for criminal purposes, its role is solely to determine what steps should be taken in connection with the premises licence for the promotion of the crime prevention objective. It is important to recognise that certain criminal activity or associated problems may be taking place or have taken place despite the best efforts of the licence holder and the staff working at the premises, and despite full compliance with the conditions attached to the licence. In such circumstances, the licensing authority is still empowered to take any appropriate steps to remedy the problems. The licensing authority duty is to take steps with a view to the promotion of the licensing objectives and the prevention of illegal working in the interest of the wider community and not those of the individual licence holder. Paragraph 11.27 states there are certain criminal activity that may arise in connection with licensed premises which should be treated particularly seriously, and you can see the list of those, and it does say for employing a person who is disqualified from that work by reason of their immigration status in the UK. Finally, members, at paragraph 11.28, it is envisaged that licensing authorities, the police, the Home Office, Immigration Enforcement, and other law enforcement agencies which are responsible authorities will use the review procedures effectively to deter such activities and crime. Where reviews arise and the licensing authority determines that the crime prevention objective is being undermined through the premise being used to further crimes, it is expected that revocation of the licence even in the first instance, should be seriously considered. Members, I don't think I need to go into any more detail here. You'll hear from everybody else present this morning, but obviously I shall be present throughout the proceedings to assist if I can. Thank you.
Thank you very much for that, Derek. Very comprehensive. Do we have any questions for the licensing officer? Councillor Magic. Just so you know, Councillor Magic's had to move because the technology is not quite working.
Yeah, unfortunately, technology wasn't working over there. Just to confirm for the avoidance of doubt, was Mr. Choi the DPS on the specific day of this incident?
The actual premises licence is in your bundle. He's not the DPS. He's the actual licence holder.
Thank you for confirming.
Thank you. I mean, I don't really have any questions on that. I think it's quite a comprehensive report as always. I'm going to move over to the applicant for the review, which is obviously the Home Office, to whether they have any questions of the licensing officer at all.
No, thank you.
No, thank you. Okay. The next person speaks. It's going to be lengthy today. It's going to be quite a process. So, is the responsible authorities, which are our colleagues here in the police. Have you any questions for the licensing officer?
No, nothing from us, thank you.
Thank you. There's nobody here from an interested party. And now over to yourselves, Mr. Walsgrove and Mr. Choi. Do you have any questions for the licensing officer?
No, thanks, sir.
No, thank you. Okay, brilliant. Okay, now we're going to hand over to the applicant's case, which is, I think, Mr. Newcomb and, was it Miss Hall, sorry? Miss Hall, okay, sorry. Apologies, I was just going to get it right. If it's Miss or Mrs, I don't want to offend anyone. You don't mind. I'm going to hand over to yourselves now to present your case to the committee and to everyone here. So the floor is yours.
Oh, thank you. A comprehensive document has been prepared, which hopefully everybody's had a chance to read. I certainly know everybody this side of the room has had a copy. As you'll see, the document contains a brief summary. We've had that already, so I won't go into that. And the interviews and the submissions, arguments as to why we are seeking a revocation of the licence. I have sitting beside me to my right the officer in charge of the case, and I think it would be helpful if you were to hear from him with regards to this matter. You will see in the bundle it's at page 39, at least I hope it's 39. The index is at page 38, and you can see there are a number of witness statements there. They have been redacted, but that sets out what happened, we would say, on the night in question when the officers attended the restaurant. So I think it would be probably at this point if we could hear from, as I say, David Newcomb, who sits to my right.
Yep, please carry on.
Thank you. Yeah, my evidence is along the lines of my witness statement. I was the officer in charge of the team on the evening in question. We entered the restaurant. Mr. Choi was the first person that I encountered. He was about 10 metres in front of me as I entered. I had directed 3 of the team to go directly to the kitchen, which is in the far right-hand corner of the restaurant. Mr. Choi instantly tried to block my colleagues from going into the kitchen. One of them managed to break away and get into the kitchen. Then Mr. Choi followed us all into the kitchen, where he was shouting in a foreign language, which I later understood to be, "Don't engage with them, don't answer." I know this because by this time my colleagues use a telephone interpreter service called Big Word, and these interpreters were saying that they're being told not to engage with you.
Perhaps if
Sorry.
Sorry for interrupting. I'm just conscious that we're all listening to what Mr Newcomb's saying, but he's saying rather a lot all at once. I don't know if it would be helpful just to, if I could just assist by asking a couple of questions, just to put it into context.
I'm happy with that. To be honest, I can't see it being unreasonable, as you're both stating your cases together, so I'm happy with that. It's not a problem.
Thank you. I think Mr Newcomb would, or Officer Newcomb would assist if you could just say why you happened to go to the premises that evening in the first place.
Yeah, we are an intelligence-led organisation, and we were acting on intelligence that there were illegal workers working at the restaurant.
So having got that information, there were, I think it was 4 of you in total, was it? No, more. There was more.
We were a team of 6. I was the officer in charge, and I had 5 officers.
What was the purpose of going there to the restaurant?
To investigate whether there was illegal working going on at the restaurant.
You said that you went in. Everybody seems to be sort of heading towards the kitchen. Was that intelligence-led? So,
my team, I had 2 people at the rear of the premises in case anyone were to run directly from the rear of the kitchen. I had 1 officer who I directed to stand at the front door to make sure any front of house staff, bar staff, no one could escape that way. The idea being that the exits are covered and that we could encounter all the people working therein.
Okay. And how quickly did you let Mr Choi know who you are and what the purpose of your visit was?
Mr Choi was the first person that I encountered. I tried to show my warrant card to him and explain the purpose of our visit and our power of entry. Unfortunately, I couldn't speak because he was instantly enraged.
And was the restaurant empty? Was there anybody in there?
No, the restaurant was quite busy. There were a lot of customers present.
So how did you try and diffuse the situation and still continue your investigation?
So, yeah, within a minute, the event, if you like, was taking place in the kitchen itself. This was having no impact on the customers at this stage. And I say that the officers were trying to ascertain the identity of the people found in the kitchen. I was still at this stage trying to explain our power of entry and explain the purpose of our visit. And I always try to work with the business owners when I go in, because I understand people are trying to run a business, and my view is until we find any illegal workers, I try to work with people. If we'd found no illegal workers, then we would have been out of there, relatively quickly.
And sorry, you were saying about being in the kitchen. So, who were the people that you came across in the kitchen?
So there were 3 persons encountered in the kitchen wearing chef's whites and aprons. There was also 3 immigration officers plus Mr Choi and myself for about 10-15 minutes.
And what system do you have in place to be able to communicate with somebody who may not have English as their first language?
We use a telephone interpreting service called Big Word.
Which language were you asking to be interpreted?
Mandarin.
And how successful was that?
Initially, it was unsuccessful because we're told that Mr Choi was shouting at the staff members not to engage with us, not to answer our questions, and yeah, they wouldn't speak.
You say we were told. Who told you that?
The Big Word interpreters said, we're being told. At this stage, Mr Choi actually at one point shouted it in English as well.
So, I've interrupted you. Maybe in your own words you could say what happened next with regards to the investigation. Mr Choi's in there trying to communicate with the staff. How were you able to diffuse the situation and continue with your investigation?
Eventually, once we'd identified the three workers, we established that they were all illegally present in the United Kingdom. None of them had permission to work in the United Kingdom, and they were all arrested. At this point, once the three workers had been arrested, Mr. Choi began to change his attitude a little.
In what respect?
He calmed down.
You conducted some interviews with the workers and also with Mr. Choi. Could you just tell the committee about that? How one goes about having an interview, getting that information?
So we don't use notebooks anymore. We use a telephone app called Pronto, and all the interviews are recorded on Pronto. You ask the question and then you record the answer. At the end of that interview, you go through all the questions, all the answers with the person you've interviewed. You ask them if there's anything they want to change or amend. If they do, then you amend it, and if they don't, then you ask them to sign it, and they digitally sign on the phone itself to say, yeah, this is a true and accurate record of the interview. The three illegal workers, obviously those interviews were conducted using our telephone interpreter service. The interview conducted with Mr. Choi was done in English because Mr. Choi speaks perfect English.
And with regards to just with each of the workers going through their interview and also checking whether they wanted to amend anything and get them to sign it, could you tell the committee, were they able to go through that process, and did they sign to confirm what they had said?
Yeah, I don't think anyone wished to make any amendments, and they signed the phone to say that it was a true and accurate record of the interview. They were quite happy with what they'd said was accurate.
And did Mr. Choi have that opportunity to go through his interview and make any amendments and sign it?
He was given the opportunity, yes.
And did he take that opportunity?
I understand he refused to sign.
With regards to asking the workers where they lived, could you just tell the committee how you ascertained that information?
So the workers were not asked where they lived as a part of the illegal working interview because that's not part of it. Once the illegal working interview had been completed, the officers then have to phone a chief immigration officer to explain the circumstances, and then it's that chief immigration officer who grants authority to detain or not. It was established that two of the three were not detainable that night, there and then, so they were going to be granted what we call temporary release. If you're going to give somebody temporary release, then you need an address of where you're releasing them to. The two persons refused or couldn't say where they lived at that time. In fact, it took about an hour and a half for all of a sudden it to come out that they were actually sleeping upstairs. Mr. Choi apparently declared at the time he didn't know where they lived, and then later on they all had keys around their necks which were for rooms upstairs.
Thank you. Is there anything else that you would like to draw the committee's attention to, or I think you might have covered it?
Yeah, I think the only added thing was that we were having a little bit of trouble with getting a signal in the restaurant itself, and so I took the point eventually to take the arrested persons back to our office where we could get a better signal. So that's where we actually served the paperwork in the end.
Thank you. Thank you.
Thank you very much. Do you have anything else you want to add, or are you happy with your case you presented?
Sir, I understand, as I say, that you have got all the documents. I don't wish to waste your time by reading through them. I know you will have read them, and there is clearly what is sought and the reasons that we seek it. Obviously, if I would seek permission to address you further if necessary. Thank you.
Thank you. I'm going to open up to members to ask the relevant questions to the applicant of the review. Do members have any questions? Councillor Swan.
Just seeking clarification on one point. You stated that 2 of the individuals couldn't be detained at that time. Could you elaborate on the reason for that?
Persons are usually only detained if there's an imminent prospect of removal. In this instance, those 2 persons, there was no imminent prospect of removal. With COVID, the current COVID climate, we try to keep people out of detention if it is reasonable.
Okay, thank you.
Any questions, Councillor Madgwick? It's just a few things. I obviously thank you for the comprehensive review there. I just want to go through some of the things that are in the statements. Is that okay? Just go through some of the witness statement. I just think reading through, I mean, so you've entered the premises. Mr. Choi has been shouting, so he couldn't obviously hear you issuing your notice to occupy. I mean, I just want to, can you explain to me, as you come in, was Mr. Choi the first person you definitely saw?
Yes, I came through the door. There are bar areas on the left. There was a table just to the right of the bar, just in front of the bar, and I believe that he was talking to some customers or service customers. He turned, looked, came towards me. I'd been advised of given a description of Mr. Choi, so I did actually say, "Are you Mr. Choi?" And then I thought that I would be able to show him my warrant card, explain who we were, why we were there, the purpose of our visit, and also explain the power of entry. But yeah, as I say, I couldn't. He was just. But
you did show your warrant card and explain the power of entry.
Yeah, in my hand,
okay,
yeah.
That's fine. I just wanted to clarify that point. And you obviously, I'm reading in the packs that Mr. Choi made various threats. Can you just expand on the various threats that were made? Because that is something that has been disputed within the representations.
Yes, so after we'd gone through to the kitchen, and I say there was a lot of initial obstruction from Mr. Choi. He pulled out his phone. He was videoing faces, videoing collar numbers, and just then he came away. And between the kitchen and the dining area is a small area, very small area. There's, I think, foodstuffs and a storage area, if you like. Here was where he made various threats to me, and he kept disputing our lawful right to be on the premises. At this stage, I invited him. I said, if you think that I'm here unlawfully, call the police. I offered him my phone to do so, but he wouldn't. At one stage, he grabbed his phone and said that he was going to call his solicitor. I said, I'm not speaking to somebody on the phone because I don't know who they are. I could be speaking to absolutely anybody. So I said, no, I won't. He gave up with that, and then he was saying things like, I know I've got powerful friends, various. I felt like he was trying to intimidate me. Okay,
so you think he was trying to restrict you within your duty, should we say?
Absolutely. The only reason I didn't have him arrested for obstruction was because due to lack of staff, because I felt he was definitely attempting to obstruct an immigration officer in the course of his duty.
So had you had the staff on site, you would have arrested Mr. Choi?
Absolutely.
Okay, thank you for that. No further questions from me. I'm going to... No, that's absolutely, as I've said, Ben, you can jump in when you like.
Sorry to interject. There has been a bit of an exchange of information between the parties since the original pack was published and disseminated. I was just wondering if perhaps you could just run through what's been clarified as a result of that, particularly in relation to the previous penalty notices regarding the premises.
Thank you for that, Ben. I think that's a really good point, actually, to make. Please go ahead.
Thank you. The information that I was given is at page 91 of the bundle at Appendix E. There was a typo clarification with regards to 2011 as opposed to 2012. And then it goes on to say, we've attended Noble House on 3 occasions, those being on the 23rd of September 2011. 1 arrest was made and a penalty notice was given. Again, on the 20th of June 2012, 2 arrests were made and again penalty notices were issued. And on both of those occasions, the monies weren't actually paid for the reasons that are set out there. I understand from a learned friend's documentation that I've lost, sitting on it, that Mr. Choi was not involved with regards to those penalties. Whilst Mr. Choi was, I think, running the, I might be put right if I'm wrong on this one, running the restaurant there, it had been leased to the chef, I think, and so the chef obviously was the licence holder and therefore liable to the fines. I think that's what my understanding is. So it wasn't Mr. Choi, it was a third party.
Right, okay. Do you want to add anything on that, Ben?
I don't believe the chef or any other third party has been the, and I'll be corrected if I'm wrong, has been the premises licence at any of the material times. Mr. Choi has been the premises licence holder throughout all of these proceedings, as far as I understand it.
Thank you. As I say, I'm playing a little bit of catch-up here. I had brief discussions, as I say, with my learned friend this afternoon. So with the licence, no, Mr. Choi's always held the licence. I think it might have been on who was running the restaurant. Thank you. I've got a nod there. So yes, so he always held the licence. Somebody else was running the restaurant.
Right. Okay.
Thank you.
Yeah. Right. Just going to ask a quick question of yourself, Mr. Newcombe. I just think this is something just pertinent to the discussion that we're having. It is redacted, which is something that I just want to make the point of. You asked in your interview, did you interview Mr. Choi or was it one of your colleagues?
No, I didn't actually interview anyone. I was the officer in charge. Right,
okay. So in Mr. Choi's interview, he actually is asked, obviously, what's the name of the business, which he replies, Noble House Restaurant. And they was asked what was the company house and VAT numbers of the business. And he gives the VAT number, but he doesn't give the company's house number. Is that odd? Or am I just picking something for nothing?
In my experience, I don't think anyone has ever turned around to me and been able to answer off the top of their head their VAT number and the company's house number.
That's fine.
Just to clarify that, as that point has been raised, the VAT number was taken from the till receipt. It wasn't that he remembered it there and then.
That's very, very helpful. I thought it was a very odd thing to ask and to be in the report.
It is a really odd question to have asked, and that's the way he answered it, by getting the till receipt.
Yeah, I mean,
nobody remembers their company registration number either.
Well, this is what I'm just getting to the precipice of, because I was thinking to myself, if you knew that, you'd probably know the other. It's just a bit of an odd thing that I was asking. So, okay, that makes sense now. On something else that was submitted as part of the supplementary, have you had a chance to have a look at the supplementary papers, Mr. Newcombe?
Some of them.
Is that, yeah?
I think if I could just clarify which document you're talking to, because I was given some as I arrived today. I think it might be that one. Yeah.
Okay, that's fine. Have you had a chance to have a look at those?
No.
No.
Do you... okay.
That is not a criticism of my learned friend. It was just that the officer hasn't had an opportunity to read through those, so he might need a moment just to be directed.
I think, Chair, this goes to the nub of the question that I was actually asking earlier, which didn't really get properly answered. There has been an exchange of emails and an exchange of information, and members have been presented with papers just as they're coming in and sitting down. And it appears that even legal counsel for the Home Office hasn't actually seen some of these papers. I think perhaps it might be wise just to adjourn for a short while.
I would like to, I was going to suggest that. This is what I was getting at because of the papers. I'd like to adjourn for...
Just to make sure that the parties do actually have all the papers in the case.
Would it be a period of half an hour just to go over what you've got? Is that a sensible
I think
time?
that's probably a reasonable time frame. And if longer is required, then we can hear from the parties.
We will adjourn for an additional half an hour just to ensure that everyone has got the exchange of information, because I'm referring to something there that obviously Mr Nicholas has seen, and I'm sure that Mr Woolsgrove... Do you have any objections?
The Home Office had those papers 2 days ago, so they had them before I even served them on the local authority. Their engagement throughout this process has been appalling, and I think it's extremely unfair that we now have to retire and adjourn a hearing for them to catch up with information that was provided to them 2 days ago, which could have been provided much sooner had they bothered to engage with me in the last 5 weeks. And I would ask that the hearing just proceeds.
In all seriousness, Mr Woolsgrove, I only got these papers yesterday, and that is with the greatest respect. I've got this paper today, which has come in, so it's within my power to adjourn, and I am going to call the adjournment because I think that is a sensible thing to do to ensure that we're giving a fair hearing for everyone. And I'm sure you will understand that. An adjournment for half an hour to ensure that everyone has the same chance to have the same view of the same papers. Okay? Thank you. We are now adjourned. Thank you. We are back live again from the adjournment, so thank you for your time. Are you happy with the information you have now?
Thank you, yes, and thank you for that time.
Thank you. I'm just going to go over the information I've got here. So, I mean, I've got the information that has come from Gareth Williscroft, is that right? Williscroft, okay. It makes, I think it's quite an important thing. It talks about the assumption regarding Mr. Choi and the civil penalty notice that was raised by our legal advisor, Ben Attrell, earlier. So, obviously, it says, to note in this case, no action was issued to Mr. Choi. It was considered a limited company as a liable party, not the individual. I've just noticed that, obviously, it's put on the Company's House a cessation for Mr. Choi as a director. Is that right?
Yeah, if I could just explain a little bit. So on the night in question, when Mr. Choi was asked his role at the restaurant, he said that he was the director. So we issued a civil penalty to Mr. Choi. When the civil penalties team later contacted Mr. Choi, he turned around and said, "Oh no, I'm no longer the director. I resigned 3 days before the visit." And Mr. Lee is now the responsible party, who's one of the illegal workers. So when we did issue a civil penalty of £30,000 in relation to 2 of the illegal workers, the third one being Mr. Lee, and he couldn't be named because he's now a director.
Okay.
Just to say, that is disputed.
Can you please use the microphone? Sorry, John.
Mr. Choi has never received a civil penalty, which is what we put in our representations. Yes, he did complete a questionnaire. I've been asking for disclosure about these civil penalties for the last 5 weeks, and that was the first response back at 10:30 this morning to set out what civil penalty had been given in relation to this particular incident. And also, I think an amendment was made to the previous information in the pack regarding other civil penalties, which also involve companies for which Mr. Choi has nothing to do with. So a civil penalty has not been given to Mr. Choi. So if it has, there's certainly no evidence of it in your
Mr.
papers.
Wilsgrove, I appreciate what you're
served.
saying, but at the moment it's members' questions, and you do have a chance in a moment to dispute what has been said. Can you just wait your turn, please?
I appreciate that, but with the
I know,
difficulty
but I
of the
appreciate
information that's been given,
excuse me.
you're hearing he's been given a civil penalty,
Mr.
which he
Wilsgrove,
hasn't.
can I just speak? Obviously, I'm chairing the meeting. You have your opportunity. Can we do this in a correct manner and follow the procedures that have been set out as the part of the guidance? Okay, you have your opportunity in a moment to ask those questions.
Of course, I just don't want you to be misled.
I don't want, but exactly this. While we're asking the questions, you have an opportunity to rebut. Carry on.
The civil penalty was issued to a company called Thomas 9000 on the 17th of March.
Okay, so the civil penalty has been issued to Thomas 9000.
Correct.
And that was the business that was running the Noble House at the time.
They were identified by the civil penalties team as the liable party.
Right, okay. Thank you for that. On the response form that has been sent back to yourselves as part of the civil penalty, the company's house number is 13478-133. Okay. There is a notice of a lease that's been given in the pack from Mr. Wilsgrove, which puts the company number as 17478-133, which is the same number as to the alleged person that they're leasing the building to. Is that? Would you say that's correct in here? So the agreement, the lease between Mr. Choi and Mr. Lee is for the business of Thomas 9000. Are we in?
If you say so, sir.
I'm just saying that I've got it highlighted here and I've got it highlighted here. They're both the same company numbers.
All I can say is that the civil penalties team are the team responsible for identifying who is the liable party. So they've issued this fine to Thomas 9000 Limited.
Okay, because it only says on the response form, it says the registered company name is A. Choi Limited. So was Thomas 9000, is that a new business or is it the same business? Mr. Wilsgrove just indicated it's the same business. So it's the same business. Right. I'm just going to go through the form here again. So it's obviously information request, illegal working, civil penalty. So we move on, and it has date you commenced trading or incorporated. So it was the 1st of October 2021 was the alleged business that Mr. Choi stated. I'm just going to make a note of it. If you go into the last page, there's a signature which is signed on the 25th of the 11th, 2021, and the printed name is Albert Choi. So would you agree that Mr. Choi was acting as a director of the business at the time of the offence?
For me personally, sir, like my role was to provide the evidence to the civil penalties team. I don't.
I mean, I only say that because of the evidence given here from the data and sanctions team from Gareth Willis-Cross actually says that the cessation, obviously, of Albert Choi as the director, you will see it shows cessation was received for filing in electronic format on the 23rd of the 11th, 2021, which is actually a month after the event took place, but it was backdated to the 20th.
My understanding is that the Companies House received that information towards the end of November, a month after our visit.
So, in your opinion, at the time, Mr. Choi was a director of the business and identified himself as such?
I can only go with what he told my team, and he told my team that he was the director.
Okay, thank you. That is all I've got to ask on that. Are there any other questions, members? Councillor Swan? No, thank you. I'm going to hand over to the responsible authorities, which is Acting Police Sergeant Rackham and PC Vincent.
Thank you, Councillor. It's, a question for Mr. Newcombe here is basically how many visits have you performed in your capacity as immigration officer?
Me personally?
Yeah.
Thousands.
Yeah.
Many thousands. I've been an immigration officer for 10 years.
Okay, thank you for that. And on the date in question, in relation, you were the officer in charge on the night, and the tactics that were employed on the date in question, are they regular Home Office approved tactics?
Yeah, it's standard procedure to block the exits to ensure that nobody can get away. To the officer in charge would normally identify himself to the person in charge, explain the purpose of the visit, explain the power of entry, and whilst that's going on, the officers will then encounter the staff working and try to identify them and try to establish their right to work in the UK.
And in relation to the visit, and obviously as the officer in charge, are you satisfied that the visit was conducted lawfully and in line with the Home Office procedures and policies that are in place?
Yeah, I'm completely satisfied that we were acting lawfully and within our power.
And obviously, the pack that we've received and the information that we've received, there's a conversation, there's an interview with Mr. Choi at the premises. In that interview, did Mr. Choi state to your staff that he was in charge?
Yes.
And in what capacity did your officers understand that Mr. Choi was in charge?
He told my officer that he was the director.
And did he state in that interview that he employed those workers?
Yes.
And in your professional opinion, were the workers at the premises illegal workers?
Yes, they are illegal workers with no right to work in the UK.
Okay, thank you.
Thank you. Please.
Just one question for Officer Newcombe. You've mentioned the Pronto system is how the interviews are recorded. Can you just simplify that for us and explain to us exactly how that system works? Is it text to speech? Is it direct text? Do the officers input it?
Yeah, the officers will input each question and each answer.
And is that typed in, or is it text to speech? It's typed in.
Yeah, no, it's typed in. However, it remembers questions that you've asked previously. So most illegal work and interviews, we've got a standard set of questions that we ask to establish somebody's roles and responsibilities, and it remembers those questions. So normally, as you start to establish the elements of, first of all, you know, the work here, remuneration, and various aspects of that, it remembers the questions. So usually you could just hit and then obviously you have to type in each individual answer.
Thank you. And just to clarify, so Mr. Choi was shown that interview once it had been concluded, and he was offered the opportunity to sign that or amend or delete anything that was in that. Is that correct?
Yes.
And he chose not to sign it. Is that correct?
Correct.
Thank you. Thanks.
Thank you very much. So we have no interested parties here today. Ben, do you have any questions you'd like to ask? No. Over to yourself, Mr. Wills. Now it's your turn.
Thank you, sir. Not specifically directed to the officer, but obviously I can answer if they've got the particular knowledge. Who was the author of the actual review application and report?
We have an Interventions and Sanctions Directorate, a part of the Home Office based in Croydon.
So who at that office wrote the review application and the report?
I'm not sure.
Are you wanting the actual name of which officer did it?
Yes.
Certainly, sir, I'm not able to answer that. I would have to make a phone call, but it would have been obviously checked before it was sent out. Sorry, I can't assist any further.
If I may, Mr. Williscroft is the head of the ISD team, and he would have authorised it before it was sent out.
Okay, so just for clarity, so Mr. Williscroft would have been the one that would have seen this before it had been handed into the City Council?
Yes, sir. I say I'm not the actual author of the submission pack. This was done by the ISD team in Croydon and then sent out.
Okay, thank you. That's fine. Carry on, please, Mr. Williscroft.
I think in the statements it states that you enter the premises by the authority of Section 179 of the Licensing Act. Do you accept that you were investigating criminal offences?
We had been tasked to visit the premises under Section 179 of the Licensing Act, and that was approved by Her Majesty's Inspector.
And that authority is effectively to investigate criminal offences, isn't it?
Where an immigration officer has reason to believe any premises are being used for a licensable activity within Section 1A or D, the officer may enter the premises with a view to seeing whether an offence under any of the Immigration Acts is being committed in connection with the carrying on of the activity.
So you're the officer in charge, so your purpose of the visit was to investigate potential criminal offences under Section 179 of the Licensing Act. So it's a yes or no answer. It's not. It doesn't need an explanation.
Yes.
It's a shame we don't know who actually wrote the report, because they're the ones that have summarised the interviews. They're not actually given in any witness statements, are they? The interviews with the workers and Mr. Choi.
No, because we don't keep pocket notebooks. Everything's done electronically, and so the visit report went to the Interventions Sanctions team, and they have picked out the salient points from those interviews.
Thank you. So it's not, you accept it's potentially not the full interview. And do you, I know you said you didn't interview any of the people at the restaurant, or nor when they were taken to the detention centre afterwards? You weren't involved in that?
No one actually went to a detention centre.
Where were they removed to then? They were removed from the premises by your officers, weren't they?
Yes, sir. We took them initially to our office in Portsmouth, where we could establish a better signal and just serve paperwork.
Because it's slightly confusing, because in the papers, which have been summarised and aren't the actual interviews, two seem to have taken place at the restaurant, as was Mr. Choi's, and then the other one is at your offices, because it's much, much later, and it is certainly after you've left the premises. So you accept there were two interviews of each person, not Mr. Choi, but the three people?
Yeah, to explain, we were having technical issues with the phone, and because obviously we're using a telephone interpreter service, and the calls kept dropping out, and it was taking time, And so I thought it was prudent to just go, it's just a couple of miles from the restaurant to our office so that we could get it completely bottomed out.
But obviously we haven't got all the information then. Do you accept that at the restaurant, the people, when they were asked questions, were not cautioned that they were being suspected of criminal offences?
They were cautioned at the point of arrest. However, this is an administrative caution. It's not a criminal caution. And the questions we ask is in relation to a civil penalty. So again, it's not a PACE interview. We don't offer people, rights to a solicitor, for example. They're under no obligation to answer those questions if they choose not to.
But you accepted earlier, in the first question, that the purpose of your visit was to investigate criminal offences, and therefore, as your 10 years' experience as an immigration officer would tell you, you have to apply the Police and Criminal Evidence Act code, don't you?
We're governed by the Police and Criminal Evidence Act, yes, but as I say, the questions that we were asking were in relation to a civil penalty.
Well, that wouldn't then give you the authority to go in under Section 179 to investigate criminal offences, would it? This
had been signed off by a senior officer who agreed that that would be our power of entry.
I'm not disputing you've got the power of entry under Section 179. I'm not taking issue with that. What I'm taking issue with is that because you are investigating criminal offences, which gives you the authority under Section 179 to enter the premises, you then don't caution the suspects before they're interviewed, and you don't offer them access to legal advice, which is what you're supposed to have done.
When you say that's what we're supposed to have done, we as I say, for a civil penalty, we don't give people a criminal caution. If we come across criminal offences, then that would be dealt with differently. In this instance, this was a civil penalty only, and so there was no need for them to be taken to a police station and given a proper, formal PACE interview.
But those are criminal offences. The civil penalty that you're issuing are criminal offences. They could be prosecuted. You just choose to take a different route by offering a civil penalty as opposed to a prosecution.
That's correct.
It's a criminal investigation, investigating criminal offences. You elicit answers from suspects that you haven't afforded a caution and you haven't offered them the access to legal advice. I mean, it's a fact because you didn't do it.
As I say, the Home Office policy is usually not to pursue this criminally. We go down the route of civil penalty notice, and so that's why we acted in the way that we did.
Yes, I know, but you're investigating criminal offences. It puts people at a distinct disadvantage, does it not, to then choose to go down the route of a civil penalty because you fail to comply with the Police and Criminal Evidence Act when you're questioning the suspects, when they should have been advised properly.
We acted in accordance with our training.
I think I'll just have to leave it there. You've seen the documentation that's been produced both by your colleague and by us. So you accept that the civil penalty issued this time is to a company for which Mr. Lee is the director?
Yes, I understand that.
And you've seen a copy of a lease from Mr. Choi to Mr. Lee for the operation of the restaurant. Can you, again, this is probably more to the lawyer than you, because it's not, I understand you're the investigating officer, you're reducing the evidence, you're not presenting the application, so I accept that entirely. So the question is generally to either of you, do you accept that legally Mr. Choi was not responsible for the operation of the restaurant and that Mr. Lee was?
Hi, is that based on this?
Use the microphone,
this
please.
Lease?
Yeah.
Just looking at the lease, sorry, I had it marked on one, not on this one. It's been backdated, is that correct?
So the lease was effective from the 1st of September.
on when it was actually sent through. Could you just help me with that, when it was actually
Sent through
to be registered?
I can't because I'm not his property lawyer. I've just been given the lease with the effective date. The date of lease at the top, as you can see, is 15th of September, and it's effective from the 1st of September.
So this is, just so that I've got the right person, Mr. Lee, who was one of the illegal workers.
Well, he wasn't an illegal worker. I accept that he didn't have the right, or we have to accept, because that's what the evidence you've adduced, and we're not here to dispute his right to remain in the country, but he wasn't employed. He was the employer as the operator of the business. Hence, his civil penalty to his company is for two individuals, the two other people that were spoken to on the evening.
Yes, sorry. I think I would have to just find my little note of when this came into, when this was sent through, or when it was backdated. I'm sorry, I had it written down.
Can you just, yeah, just please find the note. I'm happy to wait.
We'll move on. I think the principal question I wanted to ask, but unfortunately neither of the two people here representing the immigration team are going to be able to answer it, is why there has been a lack of engagement and a lack of disclosure of information that we've requested over the last 5 weeks, but I don't think either of them are in a position to answer that, which is a shame.
Sorry, no, I'm not able to assist with regards to that.
And the final question, which again, having spoken to my friend before we started, I don't think she's able to answer this either. We have proposed some conditions to this committee, but you can answer that, as to whether those would meet the causes of concern and satisfy your team, or whether you still wish to pursue the revocation recommendations of the committee.
Thank you. No, I wasn't able to answer before, but I've checked through my emails, and no, the Home Office is still seeking revocation, and that the conditions wouldn't be sufficient. Thank you. Thank you.
Thank you, sir. Those are my questions.
Thank you. Just out of interest, did you manage to find when the note? I mean, Mr. Walsgrove asked you a question about the lease. Have you managed to find out the note that you had on it? You said you had a note regarding.
Sir, I haven't. No. So I'll keep looking.
Okay, thank you. Thank you, Mr. Walsgrove. Is that no more questions at all? Okay, thank you. I'm going to hand over to the responsible authorities, so Acting Sergeant Rackham and PC Vincent. Would you like to obviously present the case and any evidence if you have it?
Thank you, Councillor. So I'm here today on behalf of the Chief of Police in supporting the review of a revocation of the premises licence for Noble House. I'm not going to go over lots of old ground that we've already discussed, but the reason for the representation is to highlight the serious concerns regarding the working practices at the Noble House. The Immigration Enforcement Team provided evidence which shows the following: that the DPS and premises licence holder was employing 3 kitchen staff who didn't have the right to work in the UK, that the same 3 illegal workers were residing above the restaurant in a flat controlled by the premises licence holder. Also, the reaction of the premises licence holder to the visit from immigration officers and obstructing them in going about their lawful duty. And the threats, which I know there's some contention around those that have been made in relation to Mr. Choi speaking to Officer Newcomb in relation to other people becoming involved in greater authorities. Also, the previous immigration visits in 2011 or 2012, I think there's some confusion over those dates, but on two previous occasions, two separate occasions, visits have been conducted at the Noble House, and 2 arrests were made in relation to illegal workers at the premise. As a result of this, immigration offences have been committed, and many immigration colleagues are dealing with this under their powers. The evidence from the immigration officer suggests that the premises licence holder had an element of control over the 3 people who were illegally working at the premise, and they were present, as was Mr Choi, at the time of this incident. It's also cited that he was allegedly trying to influence those workers and prevent them speaking with immigration officers. The interviews and the notes that we have suggest elements of coercive and controlling behaviour by the premises licence holder and highlight serious concerns regarding human trafficking and the potential of modern-day slavery. We've got serious concerns in relation to how the business is operating and their failure to be able to promote the licensing objectives. And given the severity of this nature, we feel that revocation of the licence is the only suitable way of dealing with this matter.
Thank you. Do you have anything you'd like to add, Acting Sergeant Rackham?
I think it's reiterating what PC Vincent said, but also we're looking at this very much, and there will be a lot of conjecture over, is Mr Choi in charge? Is Mr Lee in charge? Who is in charge? I think what the point that we would like you to focus on is that this is a licensed premises. This holds a premises licence, and the premises has to be run in a way which promotes the licensing objectives. Now, regardless of who's at fault, and we are not here, and you are not here to judge Mr Choi. You're not here to find him guilty. You're not here to find him innocent. What we're here to do today is to understand whether or not this premises has promoted the licensing objectives or has failed to promote the licensing objectives. From the police position, it is clear that from the evidence supplied by immigration, the Home Office Immigration Service are telling us that illegal workers were working at that premises. That raises huge concerns, as PC Vincent has said, around modern-day slavery, the potential for human trafficking, particularly in the accounts that those people have provided to immigration officers at the time, in that they are not paid a proper wage, in that they attend a point that they have been given and they are driven down to work at the premises. Regardless of who has employed them, the premises themselves, there are illegal workers there. That significantly undermines the licensing objectives, and there is nothing that you can do, the police say, to prevent that from happening. It's quite clear in law that whoever is in charge of the premises has to perform certain checks in order to ensure that their staff that are working at that premises have the right to remain in the UK and have the right to work in the UK. That is not the case. So there is nothing that you can impose on this licence to ensure that the licence conditions, the licensing objectives are promoted. So therefore we would say the only option would be to revoke it.
Thank you for that, Acting Sergeant Rackham. I'm going to pass over to members. Do members have any questions of our colleagues in Hampshire and Stavro? No. I have no questions. I think that was very thorough, so thank you. Obviously, do the Home Office have any questions?
No, thank you, sir.
No, thank you. Mr. Walsgrove, do you have any questions? Okay, thank you. There are no interested parties here today, so I will hand over now to the premises licence holder to present their case, which obviously when use the body of evidence that they have.
Thank you, sir. I think before turning to the merits of the representations which we've presented, I think it is important for me to just draw to this committee's attention the lack of engagement that there has been with the immigration enforcement team around this application, and how, in my view, that has caused difficulty in producing effectively a fair hearing for Mr. Choi today. And I'm just going to run through the chronology of my attempts to engage with officers and with their lawyers throughout this process, because I think you should be aware of it, and whatever decision you make today, whether it be to revoke the licence or to modify the conditions, whatever the decision is, I would hope that this committee would be bold enough to send a message back to the immigration team to say you need to engage in the process in a proper manner to ensure people are receiving a fair hearing before this committee. So when the review was served, I immediately emailed the email address which is in the application, asking for disclosure of various information, because some of it is clearly lacking. As I said, I've already drawn attention to the fact that within the pack there is a summary of interviews, which there should be the full interviews, and not only that, they were interviewed at the restaurant and back in the office at 2 different locations, and clearly not all of the interviews are in that. So that's just one of the examples of things that I asked for. I didn't get any response to that whatsoever. I then followed that up with a second written email on the 2nd of March, asking again for them to respond to that, which I did get a reply from an officer to say that I'd used the wrong email address, even though that's the email address they put in the form for correspondence. Apparently that's not one, that's just a general Home Office email that, you know, may or may not get picked up on by someone. Fortunately, the officer did pick it up and said that the officer in the case, who he didn't name, was off work due to a bereavement, but was back on work the following week, and that he'd passed my email to him or her. I didn't hear from them that following week, so I again chased them up on the 16th of March, saying that I'd not had a reply and asking for various bits of information. Didn't receive any response to that. 22nd of March, again chased them, saying that I'd not had a response to all of those previous emails. And finally I got an email on the 23rd of March from the Government Legal Department to say a lawyer had been appointed. So it wasn't even from the lawyer that had been appointed, but telling me a lawyer had been appointed and that they would get in touch with me. That particular lawyer then did email me the following day to say that they weren't back in the office until the 28th of March, and that I could speak to her then. So I replied to that and said, fine, I will phone you 11 o'clock on Monday so that we can discuss this case. Which I did, and surprise, surprise, no answer whatsoever. So followed it up with another email to say, we'd arranged to speak this morning, you weren't available. I didn't get a reply that day, had a reply the following day, 29th of March, so now only 2 days away from the hearing, to say that she'd been busy on another matter, and in response to all my requests for information, the only piece of information she gave me was that they hadn't yet instructed counsel. They intended to, but they hadn't yet, so she couldn't let me know who that was, and just didn't answer any of the other questions that I put in any of the communications, in the numerous emails and messages. So I was left. I've not been able to speak to anybody on this case at all. I've not been able to discuss the legality of the lease, the conditions that we were proposing, the previous civil penalty notices that were issued, etc., etc. And I think that is, frankly, an appalling state of affairs, where this is a very serious application. We're talking about Mr. Choi losing a premises licence today, and I think he should have been offered and extended the courtesy of some engagement. The Section 182 guidance makes it quite clear that the whole underpinning ethos of the Licensing Act is to work in partnership with responsible authorities, and in relation to reviews that there should be engagement. I accept entirely that the guidance says there will be occasions when engagement prior to issuing the review is not necessary. However, to have just effectively put up a brick wall for the last 5 weeks and not engaged in any conversation, not produced the information that I've asked for, I think a message should be sent back to them from this committee to say that that's not an acceptable way to deal with an application of this type, and that if anybody in this city faces a similar application from the immigration enforcement team, then you, as a City Council licensing committee, would expect them to at least extend the courtesy to the lawyer of some engagement other than just constant emails of pretty much saying, we're not giving you any information, we're not telling you who the lawyer is, who's going to attend. I don't know when my friend was instructed, but I'm guessing it was probably only yesterday at the earliest, may have even only been this morning, because you'd not seen any of the documentation that I'd sent the Home Office 2 days ago. I know you only had it yesterday, but I had wanted to engage with them first before putting in any representations. And as I said, all of the information would have come out much sooner had I had that early engagement. My intention was to put effectively Mr. Choi's case in his representations at the end of that consultation period. So the officer in his email, when I finally did get a reply back, had said that he discussed it with the licensing officer at the City Council and had been advised that Mr. Choi didn't need to make written representations, that he could simply turn up at the hearing and make his representations here, which is perfectly true, and certainly no criticism of your licensing officer. But why are they engaging with your licensing officer when they can't even pick up the phone and speak to me? There has been a great deal of unfairness to Mr. Choi in these proceedings. I have set out in those representations Mr. Choi's account effectively of what happened. We could go line by line through the evidence and put the side of the story, but I've kept it to the key points because essentially we don't dispute that the two persons for which civil penalties have been issued against Mr. Lee's company were not able to work, so that's not something on which you'll need to make any finding of fact. The essential part of this case is who was the operator at the time. So the question you need to determine is who was employing those two persons at this time, and we say very clearly it was Juan Lee who had leased the business from Mr. Choi and had employed those two persons, and I've set those matters out in some detail. Mr. Choi certainly does dispute some of the information the officer has given you about how abusive he was. He certainly refutes any suggestion he was coercive. It's interesting, I heard Officer Newcombe say that the translator was telling them that Mr. Choi was saying to the other people not to say anything. None of them mentioned that in any of their witness statements, and indeed there's a statement from one of the officers which says, I heard him speaking in a foreign language but I didn't understand what it meant. Well, if he had had the interpreter on the end of the phone telling him what he'd said, then why would he write that? It seems odd that at the hearing, after we've sent in our representations to say that he was trying to assist and trying to calm down the members of staff. I mean, imagine 6 officers in uniform bursting into the restaurant and making their way straight to the kitchen. They certainly were scared. And yes, Mr. Choi certainly was agitated because he didn't feel that he'd been given adequate explanation as to why the officers had come in, and in any event 2 of the officers had gone straight past him to the kitchen in any event before he'd even had a conversation. So it's understandable to see his reaction. He refutes any suggestion that he made inappropriate physical contact with any of the officers, and his talking to the staff was simply to calm them down, to explain that the people there were immigration officers. And if he was being so coercive and uncooperative, why on earth did he provide all their names to one of the immigration officers, which is concerned in their witness statement? It doesn't add up with what you've heard from the officer about how Mr. Choi acted on the evening and how coercive and abusive he was being. And in addition to which, to again add in that finer detail in the hearing before you, which certainly wasn't included in any witness statements about wanting to arrest him for obstruction, but failing to do so because there weren't enough officers. Well, I'm pretty sure if he thought that they had sufficient evidence to warrant that, they would have written it in the statement. And I'd certainly fail to understand why 6 enforcement officers wouldn't be enough to arrest one person, because you heard they weren't going to arrest the other workers there. They were simply asking them questions which might lead to a civil penalty on their account. So it just seems a little convenient that that extra colour has been put onto the witness statements, when frankly in legal proceedings officers who have attended under a specific purpose, section 179 of the Licensing Act, and made witness statements should include everything in their witness statements. Those bits which are missing I've asked for disclosure and haven't got, so we don't know what the missing bits of the evidence say. But in any event, this case in my submission rests on the basis that Juan Lee was the operator of this restaurant, not Mr. Choi, and that Mr. Choi, with the lease to him of that premises, is in the same position as many other businesses up and down the UK, where the freehold owners or the principal leaseholders will hold the premises licence, and then others will operate under that licence. So I've produced to you the authority of Hall and Woodhouse, which I accept isn't a licence review case, it is a criminal case, but it is authority for the proposition that it's standard, or a considered standard business practice, that the licence holder may not be the person that's carrying out the licensable activities at the premises, and that criminal offences cannot be imputed onto the licence holder by the conduct of third parties. And that's exactly the scenario we've got at Noble House Restaurant. You've got the legal document before you for the lease, which came into effect from the 1st of September, dated 15th of September. You are asked to take account of the fact that the change in the company from A. Choi to, I can't remember the name of it, but whatever is the civil penalties been issued into the name of it. So the company name was changed. Again, it's perfectly standard business practice, and Mr. Choi has done this in the past. I've certainly got other clients that do it as well, where they have premises, they will have effectively a shelf company. So A. Choi Limited was effectively a shelf company, from which then when people purchase the lease and the operational side of the business, rather than them having to go through all the legal process of setting up a new limited company, they can take that company and change the name and become a director. And that's what happened in this case, and that's what's proved by the records on Company House. And there's no issue over saying, well, the documents were filed in November and they took effect in October. That date in October is the legal date by which that company had Mr. Juan Lee as the director. But that is irrelevant. It's the lease. It's the actual business practice within the premises, and Mr. Lee was responsible for those premises long before the changes to the company names, which even predated the visit in any event. So I'm asking you to accept that this is a common practice where the licence holder may lease the business to someone else, either under a tenancy agreement or, as here, a 5-year lease, that Mr. Choi is not directly responsible for the employment, and accordingly the crime and disorder objective, in my view, has not been engaged for you to revoke his licence. When discussing the situation with Mr. Choi, I explained to him that in my professional capacity and my experience, where I've come across these business practices, I have advised clients that it's not a good situation to be the licence holder when somebody else is effectively running the business. For this very reason, you end up in a mess which is not your own doing, and in those circumstances I've always advised my clients to ensure that the tenant applies for their own premises licence and that their licence then stays as what's called commonly a shadow premises licence. So for example, when we licensed Southsea Pier, the owner of Southsea Pier has a premises licence for the pier, and then each of the tenants in each of the different units have got their own licences for each individual business. That was on my advice, because I said if you just let those tenants come in and run their own businesses and they do something wrong, then you have this sort of consequent risk that you could be before a licensing committee for things that you've got no control over. And so that's what I've proposed in the conditions, to actually make it a condition that if he chose to lease his business out in the future, obviously since Juan Lee did a moonlight flip owing him considerable amounts of money, and he's now controlling the restaurant himself, if in the future he decides to lease it again, that the condition would require that person to apply for their own premises licence, and they wouldn't be able to operate Noble House Restaurant under Mr. Choi's licence. We accept that the position of the designated premises supervisor is different to that of the licence holder, and they should have had some knowledge of what Mr. Lee's decision making was over the employment of staff. And so we've said to you that the DPS should be removed from Mr. Choi's licence, as well as the condition about the third parties always having to apply for their own licence. In addition to which, and I know the immigration team do not accept adding a condition about having proper HR policies in place to ensure all employees are all employees are legally employed, because they say, well, it's a statutory duty anyway to make sure that someone's lawfully here to work. And I agree entirely that that is obviously a clear statutory obligation, but I think that condition does go further than that obligation, because the keeping of records and the production of records on request would allow very, very simple enforcement action. I think the author of the report, whoever that was, we don't know who it was, but the author of the report points out how difficult it is for them to prove in a criminal case who the employer was, or even in a civil penalty who the employer was, asking you actually not to consider evidence and to use your common sense, which I find a quite bizarre submission, frankly. You have to deal with evidence. I know it's generally considered to be an administrative decision about licensing. However, a lot of the evidence is in dispute. The standard of proof is, in my respectful submission, on the balance of probabilities, and you do have to consider that evidence. That condition about requiring these HR policies and documents would make enforcement very simple, and it would give the police officers here and the immigration team a really easy way of proving anything went wrong in the future, which the statutory obligation they say exists, which you have to employ people legally, does not do so, which the author of the report has said that's the case. It's very, very difficult to prove. So that condition, in my respectful submission, does go way beyond that statutory duty, and we're asking that those conditions and the removal of the DPS would be a just and proportionate response to allow Mr. Choi both the decision to operate the restaurant in the future, which he has done. You've heard he's owned the restaurant over 30 years. During that 30 years, he has had a number of operators in that business, but he's also run it himself from time to time. His current intention would be to run it himself, and his wife will be joining him on a day-to-day business, so that is to the short, medium term, but he wouldn't rule out leasing that in the future. And so those conditions we say would protect that. You haven't heard any evidence about any other issues with this restaurant, so it's been there 30 years. The evidence about the two previous civil penalties are identical to the circumstances before you on this occasion. Mr. Choi had leased those premises to other people who were responsible for the employment of those persons, and those companies which received the civil penalties had nothing to do with Mr. Choi, as they don't now. So the three occasions, 2011, 2012 and 2021, had nothing to do with Mr. Choi. He is a very well respected businessman, a responsible licensee. The 10 people that have written in, you can see from their effective character references about his honesty and integrity and how highly regarded he is. I ask you to take that into account when considering some of the issues which are in dispute about what happened on the night. But overriding all of that, I say legally he was not responsible, and so as the licence holder he should be allowed to continue to hold his licence. Those extra conditions will make sure this confusion is never going to happen in the future and put the responsibility firmly and squarely on the third party who will have to get their own licence. But if Mr. Choi's running the business at the restaurant, he'll have those HR policies in place. We're already a fair way down the road with people forced to get these policies in place. We've got that final bit of work to do, which is entirely subject to your decision today whether you let him have a licence or not, because obviously if the licence is revoked then he's not going to continue to pursue those new policies. What he has done since this review has been submitted is install CCTV in the premises, and it's, from my point of view, it's a shame that that hadn't been in place on the visit, because we would have been able to see exactly what happened when the officers came in, how customers reacted, who obviously they were just as shocked and eventually they were all told they had to leave, and how the staff also reacted. I didn't put that in as a condition, but if that were also something you thought would promote the crime and disorder objective, then you could also add a condition requiring the CCTV. The standard condition this committee would normally put on with the 31-day maintenance of recordings, etc., etc. So I appreciate I've taken up a lot of your time. I'm grateful for you for having read through those papers. If you need me to provide any more explanation about the particular legal authority I've produced and the question of law, then obviously I'm happy to do so.
Thank you, Mr. Walsgrove. Members, do we have any questions? Councillor Madrick.
Mr. Walsgrove, I've actually got quite a considerable number of questions, so please bear with me. Just a point of clarification, first of all. In your supplementary information, which we received yesterday, in point 3, you stated that he has owned the premises for nearly 3 decades. However, in Appendix D on page 71, his landlord, Mr. Ahmed, said that he's been a tenant of the property for 15 years. Could you please clarify which one is correct? Has he owned the property for 30 years, or has he been a tenant for 15?
30.
30. And he's owned that or tenanted?
It's on long lease.
It's on a leasehold for a long lease. Okay, wonderful.
So my apologies. Mr. Choi at one time owned the freehold, and then on selling the freehold, part of that transaction meant he now is the long leaseholder.
Okay. I know there's been a debate over whether or not he said that he had a lot of powerful friends. However, it seems by the letters of support that he does. In reference to one of the letters of support, which is from our Lord Mayor-elect of Portsmouth, Councillor Hugh Mason, he stated that over the years, I've learned that from the local Chinese community that Mr. Choi is indeed well respected by the Chinese embassy, and that very senior officials have dined at his restaurant. In paragraph 2, it states that I have long been aware that Mr. Choi provides accommodation for legitimate asylum seekers who are prohibited for taking paid employment and have little or no recourse to public funds, which is on respect, a very nice humanitarian thing to do. But within reason, that would mean that, given the fact he's the chairman of also the local Chinese Association, which is once again a wonderful thing, surely he would be aware of the people that he's allowing to live in his private property. He clearly is aware that these people have no right to take paid employment as on a testimony. So surely when he was in the restaurant on that Saturday night and saw these people in his kitchen working, he would be aware that they're not eligible to work, and surely he'd have raised that with the so-called new leaseholder?
Just in relation to the first comment about having powerful friends, as you've seen in my written representations, he disputes that he said that in any event. That, he says, must have been a confusion where he'd mentioned about having a very important customer that, etc., etc. You're nodding, so I won't labour that point. No, he didn't know that the two workers were not able to work.
Okay. Obviously, there's a dispute about when the contract was signed. The lease states, I believe, just confirmed the 1st of September, we believe.
That's the effective date.
That's the effective date.
Correct.
And obviously there's a dispute about when that was signed. However, surely for transparency, do you have any form of bank statement of a payment that's been made to Mr. Choi for respect of this contractual business? Because surely if he's leased it out to somebody, he will have a bank statement with proof of funds backdating prior to that October date where the immigration officers come in. Thus, it would null and void our argument to decide whether it was an effective lease or not, because there'll be a payment, surely.
I wasn't aware that anybody was going to challenge whether it was an effective lease, so no, there aren't, and he hasn't paid him any money.
I think on the point that Councillor Madrick's making, Mr. Walsgrave, you've made several points stating that Mr. Choi wasn't in control of the premise, wasn't in control of the business at the time. I think what Councillor Madrick is trying to ascertain is, can you prove that? Because at the moment we're taking your word on it.
Well, I've produced a copy of the lease, which is effective from the 1st of September.
A lease can be backdated. I could sign a lease now to say that I rented a property from the 1st of January 2010. Doesn't make it it doesn't make it that I didn't backdate it. A bank statement cannot be changed. So if there's a way that we could see any form, even if we have to go into a break and Mr. Choi can go get proof of that, surely that would completely and utterly satisfy the entire room's, question of whether this lease was effective or anything was effective prior to the date of the immigration's entrance.
I think it would take longer than half an hour, but if you wanted to adjourn these proceedings off to another day, then we'll adduce other evidence to prove it. As I say, I had no idea that that would be a challenge.
Just a point of clarity, did you say that you had a note of when the lease was backdated till? I think you might be able to help quite.
It was just attached document from Companies House for cessation of Albert Choi as director. You will see that it shows the cessation was received for filing in electronic format on the 23rd of November 2021, but that the cessation was backdated to the 20th of October 2021, which obviously was 3 days prior to the officers visiting.
Right. Okay. So I think Councillor Madrick, you're making a point about the lease. I think that clears up whether Mr. Choi was a director of the business at the time. The only thing I find bizarre in this is that effectively Mr. Choi was a director paying himself the money at the time, which I find bizarre. But we can clarify that another day. But I think. Thank you for that point. I think it clears up a lot of things. Councillor Madrick, unless you have anything to say, Mr. Walsgrave?
Just on the point about him being a director, that's where, as I say, setting up effectively a company, you have to name a director. He was a director with the intention that at some point, whether it be for this particular business or any of his other businesses, that he would sell on and people could then just effectively move into having a limited company set up. So I have numerous clients with numerous companies which aren't actually operating, and they're kind of just sitting there waiting for someone to take them over. They'll then change the director to themselves, may change the name of the company. Obviously it had to change because it was A. Choi Limited, I think, before, and obviously Mr. Choi is not going to want his name on someone else's company. So that's the reason why he's named as director. It's not because he had any involvement in the operation.
So you accept he was a director?
of the company initially, but not of the operation of the restaurant.
Well,
It's a tool, a business tool, a legitimate business tool, where someone just comes and acquires the company and they don't have to go through all the legalities of setting up their own company. They
Yeah,
can
I
just
mean,
okay, carry on.
yeah,
Councillor
I mean,
Marshall.
that is a legitimate business tool. It's one that I'm fully aware of. So, I guess the question is if Mr. Choi was in there on a Saturday night working, which we're all in agreement with he was doing, why would he lease his business out to somebody else if he was going to willingly work on a Saturday night? I think that's a really interesting point.
So as part of the agreement with Juan Lee, obviously he's taking on a new business in the area with a very established brand, if you like, because obviously Mr. Choi has had it named as Noble House for many years. It has many loyal customers, and as part of the agreement, he, as well as other members of his family, were to work to ensure the smooth handover of, effectively, the goodwill, to make sure the restaurant carried on making money, so that Mr. Lee could then pay him the rent under the lease, which is the commercial part of Albert Choi's money making, if you like. That's where he wants to get rent and not work, and in order to do so was assisting Mr. Lee to make sure the restaurant would be successful so that he could afford rent. It wasn't he was going to be employed there forevermore for Mr. Lee. He was going to be employed there during that sort of handover period. He was only there generally at the weekend, so the busy nights when, you know, the restaurant is packed, so on a Friday and Saturday night, just to keep that brand, if you like, going for that transition. So that's why he was working. Certainly his plan was to not work as quickly as he possibly could, as it is now. So that although I've said he's now back operating the restaurant again with his wife, ultimately that will be a short-term view. I mean no disrespect to Mr. Choi, but he's no spring chicken, and he doesn't want to be working in a Chinese restaurant. He'd rather be collecting rent.
Okay, so obviously I've read your supplementary information, and obviously you've given a really good account of Mr. Choi's experience, the fact he's been a licence holder for decades, and he worked at a national pub chain around the country. It just seems strange to me that somebody with so much experience and knowledge would lease a premises and not set up a shadow lease or a premises licence, or not change the DPS. Honestly, what was the reason for that? Because I know if it was mine and I was handing over my name to somebody, which I didn't even bother to check the legalities of that person's work, that I would certainly not want my name on that premises. So why was that just not done as a due diligence process, bearing in mind how experienced Mr. Choi is in the national industry?
That is how he's conducted his business throughout the last 30 years. So as I've said to you, he has leased it previously, and the issue of shadow licensing is not a common nuance that people are aware of. You are, I am, because we're experts in that field. There are plenty of operators out there who aren't, and you could say the same of people like Hall and Woodhouse Punch Taverns. Why do they hold the premises licence and leave it to somebody else? Why don't they make them apply for a new premises licence and the pub companies just have shadow licences? They don't do it.
Just on that point, Councillor Major, I just want to intervene. I mean, on your submission, point 11, on two previous occasions in 2011 and 2012, Mr. Choi had leased the premises to others. So now this is the third occasion where Mr. Choi has leased the premises to others, and there's been various accounts of illegal working. I'm just going to make the note that you said about a shadow licence. Why was that not looked at in 2011, and why was it not looked at in 2012? Because I think once is unfortunate, twice is, you know, we're pushing it. 3 times, I'm starting to get the impression that I would have been screaming for this after the second time if it had been me. And why was that avenue not taken?
As I said to you, because the vast majority of people out there will not know what a shadow licence is or how that works. And given that no action was taken against Mr. Choi on those 2 previous occasions whatsoever, so no civil penalties, no criminal prosecution and no premises licence review, he thought it was a legitimate business practice because his licence stayed intact and no one questioned it.
I just find it surprising, Mr. Walsgrove. I mean, as you noticed, Mr. Choi has worked for massive change, and would it be? I would assume that he would understand that that would be a requirement.
I think you're imputing knowledge onto him with your own expertise that operators don't have. So, for example, did you know in Scotland you can't have a shadow licence?
Yeah, I did.
So
know
the
that.
law's different. You did. I bet Mr. Choi didn't. I bet most of the other people in the room.
There's a lot of things I know that I shouldn't know.
That's what I mean.
I would argue, though, that if somebody's worked for a national corporate brand across 5, 6 cities, that they probably would give. I mean, in a corporate industry, maybe not a sole trader in a local small business that employs 5 people wouldn't be expected to know that, but I would expect somebody from a national brand corporate chain to know these kind of simple
Why do
things.
those national chains have their own licence then?
Some do and some don't. I'd be interested to know which national chain you work for if you want to disclose the information, because some do and some don't. So that would be interesting.
Well, they're now known as Mitchells and Butlers, but obviously the licensing regime from when he worked in the pub company business was the Justice's licences, and all of this talk about shadow licensing, etc., was completely irrelevant because the Justice's licence had to be held by an individual person, not as they are now by companies and premises licences. So the whole world of licensing back when he was working for pub companies under the 64 Act was completely different.
Okay, I've only got a few more questions, so
Please carry on.
Thank you for being patient, but I do want to be thorough in this because I think it's quite important for everybody in the room. I'll get to the more simple questions first. If Mr. Choi was indeed an employee of this company, as you're stating, and he stayed on an employee role, did he have any employee contract? Was he produced any pay slips? Was he on a payroll? Is there anything like that at all, or is he just free in as a volunteer?
It wasn't free, it was paid, and there is payroll. But I obviously can't produce anything.
Okay, so we can't produce payroll, we can't produce bank statements of lease payments so far.
Just to confirm, he wasn't paid anything by Mr. Lee. He's owed money.
How much?
Over £6,000.
So, obviously it seems suspicious that every time Mr. Choi is accused of these offences, in reference to 2011, 2012 and now 2021, that there's suddenly a lease that pops up that somebody else has taken the fall for, and then the company dissolves and closes down. In point 12 of your document, it said that obviously throughout the ownership of Noble House, he has leased the premises to other businesses, but he has operated the restaurant himself at times, and he does this currently, and is flexible. Do you have any examples of any leases that he's done between 2012 and 2021 which were efficient and worked? Have we got any? As in, I'm trying to ascertain whether he just did 3 leases, which happened to 3 of them go wrong, or was there any in the middle that was successful? And have we got any proof?
No, I didn't expect to have to produce that sort of evidence, but I dare say again, if you require that, if these questions and answers are make or break as to whether you revoke the licence or not, so for example getting a catalogue of back leases, etc., then adjourn the hearing and we'll look into it. I can't answer that today, I'm afraid. I'm presenting the case on the basis of this incident, not the 2 previous incidents.
I'm going to be minded to say what you've just said, Mr. Walsgrove. I think we should be basing it on the evidence we have in front of us today. I think what you're trying to get at, Councillor Madry, is trying to ascertain the facts of what's going on. But at the same time, I think we have significant evidence in front of us to deal with what we've got.
I agree, and I think the only comment I can add is that obviously, so the new Licensing Act came in 2005, so that's 17 years worth of trading, and there's those 3 occasions in 17 years, so it has to be, we would put forward the case that, well, for all the other times, you know, the operation has been run accordingly. There's never been any concern raised by any responsible authority as to the way the business is run in terms of promoting the licensing
That's fair. I'm just kind of trying to search for. I was just trying to search for anything where it would give me some factual proof to base that what it's saying is factual. You know, that's all it was. I'll move on. So I've only got literally two more things. In reference to what you said in your opening statement there, you said that obviously Mr. Choi had absolutely no connection to the 2011-2012 incidences. I've been looking at Appendix E on page 91 from David Newcomb, and it clearly states obviously the penalties for the previous businesses that were given penalties for, one being a Birmingham 18 Limited, penalty not paid, company dissolved, not pursuing, and on the 20th of 6th 2012 two arrests made, penalty points to 2018 Limited. What I find quite strange, I just wanted some clarification, because you said that Mr. Choi had absolutely no knowledge of these people and didn't have any business dealings with them. But I've done a bit of research during our break, and it seems that both of these businesses are connected to a gentleman called Simon Hwan Choi Poon, who is 5 years Mr. Choi's senior, and has been named on just over 2,000 companies on Companies House that have either been dissolved or he's resigned from. What alarms me about this more than anything is that he was named on both of the companies in 2011 and 2012. I'm just wondering why Mr. Choi would have leased out a property to somebody which had illegal acts, and then 1 year later leased out a property under a different company name.
Do you want to jump in?
Yeah, I think I was just waiting to see if Mr. Walsgrove made a comment. I expect I'm preempting what he's about to say, but I do have concerns about members conducting their own research and members introducing evidence into these proceedings. Mr. Walsgrove, if you feel that you want to or need to answer that question, please feel free to do so, but my legal advice to the subcommittee is that they should not take into consideration any research or as far as I'm aware, this is the only research that members have conducted independently.
Okay, I'll step that question aside then.
I do just want to make one comment on that.
Within your right to.
Which is this. I think in my representation, if I hadn't made it clear, then I will do so now, is Mr. Choi had no knowledge of those civil penalties or the conduct of those investigations at that time, and because he was leasing the premises, had no operational control over them either. So I wouldn't be able to answer your question about why did he then lease it again to another company, because he didn't actually know that those proceedings had been issued.
Okay, I'll sidestep that and I'll wrap it up then. It's just the final point, which is quite relevant because we've discussed this today. In point 23, obviously it states about the law surrounding the incident. In the final paragraph of that point, which you can find on page 6, it states that if he had been advised properly by the Home Office there, that he would have produced the lease at the time and informed that he was not the operator. Now, as an experienced businessman of Mr. Choi's level, and obviously a great understanding of the English language, which everyone accepts, why would he not have immediately at that very, very point said to the officer, well, I'm not actually the director or owner, it's somebody else? Why would he?
Because he didn't understand that the investigation was looking at giving him a civil penalty or the potential criminal proceedings or revocation of the licence.
Do you not find it strange that, bearing in mind Mr. Lee was in the property at the same time, that Mr. Lee wouldn't have stepped forward for these questions or to speak to the officer there? Would that not have been sensible, rather than Mr. Choi stepping forward if he wasn't the owner?
Well, Mr. Lee was the chef, so he was in the kitchen, so he didn't see the immigration officers come in. And if you want to avoid being prosecuted, then of course you don't step forward and say, yes, I'm the owner and operator.
Interesting. Okay, well, no further questions. Thank you for your time.
Okay, thank you. Thank you for that, Councillor Magic. Councillor Swan.
Yeah, just a couple of questions for clarification. Just on a point you've just said that Mr. Lee was the chef at the time. I'm sure it was mentioned earlier in this meeting that it was claimed that he wasn't actually working there and that he was just that he wasn't one of the people that a fine was levied for?
That's correct, because he was effectively the employer. So he can't be fined for employing himself effectively, because he's a director of the company. So had Mr. Choi received a civil penalty for employing them, it would have been all three. But as Juan Lee is the employer, there were only 2 illegal employees, so he gets 2 fines.
Okay, understood. And my final question is, if Mr. Choi was working for Mr. Lee in order to keep to assist in keeping the good name of the business and to ensure that continued, would it not have occurred to Mr. Choi to actually perhaps inquire as to whether new people that came in to work in the business were actually doing so legally?
That's not his responsibility. He can't tell people how to run their business. Once he's leased the business to someone else, it's up to them how they want to run it. And Mr. Lee, as I say, had asked for that assistance. Mr. Lee could have taken the decision not to ask for any assistance. Mr. Choi's agreement to work with him was not to maintain the brand for his own reputation. It was to maintain it so that Mr. Lee could make enough money to pay his rent under the lease.
Okay, but as the license holder, and you know that's not in dispute that he is the license holder, would that not have occurred to him to actually, because essentially the business is operating under his name as the license holder, would that not have occurred to him to ask the question about whether staff that were working there were doing so legally?
It didn't occur to him, because that had been his business practice, over the last 17 years under this Act. And as I say, had he come to me for advice as a licensing expert, then yes, I would have said to him, look, Mr. Lee needs to get his own premises licence. But as I've said to you, it is common practice where companies and freeholders of property hold the premises licence in their name and let other people come in and run the business. So it's not unusual. I know you may not have come across it in a review application before. I certainly have. It is more common than you think, and the condition I've suggested will avoid it happening ever again.
Okay.
Thank you. I'm just going to go through a few things, Mr. Walsgrove, if that's okay. I say that's okay, I'm the chair, so it's fine. It's good with me. Okay. 2 seconds. Appendix. Sorry, just find myself. I found it and then I started looking at something else. Okay, Appendix C, which is a copy of the premises licence. So, it's quite a standard document that we've seen before. Can you just tell me the name it says under the name and registered address of the premises licence holder?
The DPS?
No, the premises licence holder. Not the DPS. The one above that.
Albert Choi.
Thank you. So would you agree that Albert Choi is the licence holder for the premises?
Yes.
Okay, thank you. I just want to clarify that, because it was a point that was made earlier by Acting Sergeant Rackham that we're discussing a premises licence and who operates that premises licence and who is responsible for that premises licence. And we are talking about Mr. Choi. I just want to...
Talking about Mr. Choi, but you also have to take into account the legal precedent I've adduced, the Hall and Wood House,
no,
which doesn't strictly align with Acting Sergeant Rackham's view.
No, I know. I just want to make that point. I mean, Acting Sergeant made that point, so I think it's worth asking that question. At the start of your submission, you talk about a lack of engagement and fair hearing. Do you feel you've had a fair hearing today from this committee?
Absolutely. From the way that this council has conducted the hearing, we have received a fair hearing. Has Mr. Choi received a fair hearing overall? No, because there is information I've asked for which I still don't have, which may have changed the way in which the case could have been put. It may have required me to then elicit some further information that I've been asked about, and I would hate to think is going to have a negative impact on your thinking because I can't produce exactly what you want. But you have conducted the hearing fairly. I was happy to proceed. I could have come and asked for an adjournment and said, I haven't had any of this information, I want an adjournment. I didn't, because this is incredibly stressful for Mr. Choi, and he wants a conclusion to it today. So I decided to proceed in the absence of that information. And yes, I'm satisfied we've had a fair hearing as far as it goes, and you could have done nothing more, and I had the option to ask for an adjournment, and I didn't do so for those reasons.
Thank you, Mr. Woods. I just wanted to clarify that, because I just wanted to, obviously, you've made reference to the Home Office. I think this committee needs that clarification to know that we are giving you a fair hearing.
Absolutely. I think, again, if I didn't make it clear, I'll make it clear now.
Thank you.
I went through that because whatever decision you make, I think a comment needs to be made
I think so.
back to the immigration enforcement team to say, that's not how you do things.
Okay. I'm going to move on. We've seen you made reference to the witness statements, and I don't know if you can answer this, but was Mr. Lee one of the people that were interviewed?
Yes.
So Mr. Lee had the opportunity at the time to state that he was a director of the business and was running the business.
Well, he could have said that.
He could have said that, but he chose not to.
No idea. Nobody can answer that except Mr. Lee.
Well, I'm just going to go from the evidence that we've got in front of us that says that he had that opportunity to do so and he did not.
Wasn't asked specifically because it was assumed he was a worker.
And I think, if I just use this correctly, that the 3 people that were interviewed for illegal working had only been in the country for a short amount of time. Is that correct?
I don't know.
Just so I'll hand over to you. Can you ascertain that for me?
No, I can say that they've been illegally present in the United Kingdom for quite considerable time, but I'm not at liberty to discuss dates or their individual immigration cases, I'm afraid.
Okay, thank you. I'm just going to go through some of the witness statement on it.
I think you may have mistaken that for they may have been in the Portsmouth area.
Yeah, I think you're right actually about that.
The UK.
I think it can be ambiguous because it says arrived together 2 weeks ago, for example. So in the Portsmouth area for 2 weeks. I think is that fair?
Workers, yeah.
Yes. Okay. That's fair. Mr. Choi, being a long-standing business person in the city, and obviously there was various representations made from various individuals, from councillors to senior officials in the Royal Navy. Do you think Mr. Choi would have known whether the people working with him should have been there or shouldn't have been there?
What do you mean?
Because, I mean...
Should he have known their immigration status?
Yes.
It wasn't his responsibility, so no, I wouldn't say he would have known or should have known or could have known.
Okay, that's fine. I've got nothing really else that I want to add, to be honest. Does anyone else have anything? Go on, Councillor Madger.
Yeah,
you're on a roll today.
Just picking up from your point, Scott, I do think it's reasonable that he would know their status because he's letting them live in his private property in a flat upstairs. If someone was moving into my private property, I'd want to know a little bit about them.
The request came through the society, as I've said, and it's not his place to question someone's need for accommodation.
What I'm actually going to finish on, there's several disputed and refuted allegations that have been made from the Home Office to which you've disputed today. And I think it's especially when the promotion of the licensing objectives about assisting responsible authorities when they do enter a premises. As someone who has gone on licensing visits with our officers, we are always actually, I'd probably say mostly welcome in most premises that we go into, and there has been some allegations that Mr. Choi wasn't. So what I'm going to ask is, and through you, Mr. Walsgrove, because I don't know if Mr. Choi will be able to speak, would be to actually outline what, in his words, actually he felt happened.
The officers came in, and his recollection is that officers were making their way to the back of the restaurant, which is where the kitchen is, and so as they came in, he said they came in a number, 3 or 4, he can't remember how many, but obviously they're dressed in dark uniform. It's a busy night, people are enjoying themselves. To have that many people come in, and he said, you know, visibly there was a kind of reaction from everybody within the restaurant. He stood up and walked over from the bar area where he was, and was saying, effectively, said he put his arms out to say, "What are you doing? You can't come in." That sort of, he can't remember exactly what he said, but what he did say was, you know, before he received the explanation as to why the officers were there, one of the officers had made his way past him, but obviously where he sort of said, "Stop, I effectively want to know what's going on." The officer had gone past him, and the other officer then tried to explain why they were coming in, and he obviously wanted to know where the other officer was going, and when he got into the kitchen, obviously those 3 people in there, again, the expected reaction to suddenly seeing official people in uniform, were scared, and he did speak to them in their own language. He certainly doesn't recall that when he was speaking to them in their own language that there was an interpreter on the other end of the phone. He thinks that comes later. He certainly refutes any suggestion that he was being coercive. And as I said to you, he wrote their names down on a bit of paper which was in the kitchen area. So the suggestion that he was shouting, and effectively there's a couple of allegations where he grabbed people. He said that didn't happen. He said he may have, where he'd effectively said stop, where he said he raised his arm as a barrier. The officer walked past him. He said he may have brushed his arm, could have done that, he can't recall, but he certainly didn't make any gesture to stop him from coming in. And then after they'd come out of the kitchen, I don't know whether you're familiar with the premises. It's not a particularly large restaurant. There's only maybe 8 or 9. How many tables have you got in there? 8, yeah, I've been there a few times. So 8 tables. It's quite a sort of cramped space. So this suggestion about him sitting nearby and being coercive, it wouldn't have mattered where he was in the restaurant. He'd have been near them because it's so small. Even my reading of the officers' statements, in my view, obviously you've got to form your own views, that they've exaggerated the situation in their statements as far as I'm concerned. They've given their opinions as to whether he was coercive or not, and not all of the information from the officers corroborates with each other. So there's things like they've got the times wrong, things like saying they had the interpreter on who interpreted what Mr. Choi was saying. Not one of them has mentioned that. I just can't. I was taken aback when I heard that this afternoon. So there is holes in that evidence. We say some of the opinions expressed about how coercive he is have been exaggerated, and perhaps the frustration is because they thought they were effectively dealing with Mr. Choi, and they've realised that it's Mr. Lee that is the person that's responsible.
I'm just going to address Mr. Choi. Is that an accurate representation of what happened on the evening? Yes, sir. Do you want to just pop it into the mic? So.
Yes, sir.
Yeah, thank you, Mr. Choi. I just thought I'd get that because I know it's coming from Mr. Walsgrove, who you've instructed, but I'd like to hear it from you as well. So appreciate that. Do you have any more questions before I move on? I'm happy to. Do you want something? Actually, yes, please, Ben.
Sorry, Chair. I don't have a question as such, but I thought before you move on to the next stage of the hearing, it might be an idea for me to address you on certain issues that have been discussed during the course of the hearing.
I'm happy for that, yeah.
And doing it at this stage enables others to comment or to deal with it if they feel they need to. The first point is that's been asserted is in relation to particular pace failings in relation to the interviews that took place. I do need to stress to the subcommittee that this isn't a criminal prosecution.
Absolutely.
You're not determining guilt. That has been stressed during the course of the hearing, and that if there are failings in terms of pace, that may have implications for a criminal prosecution, but that doesn't prevent you from taking the evidence into account and attaching the weight that you see fit accordingly. You have heard that the interviews are a contemporaneous note or a contemporaneous account, and those giving their accounts were given the opportunity to rectify those documents. The second point is in relation to the assertion that the relevant determination for the subcommittee is whether Mr. Choi employed the 3 persons asserted to be illegal workers. My advice to the subcommittee is endorses the view of the police, however, is that it's a wider consideration, and I'd make reference to paragraph 11.28 of the guidance, which indicates, and that does appear in the officer's report to you, which indicates that it's the use of the premises.
I'm literally looking at that guidance now, thank you.
Rather than the strict determination as to whether or not Mr. Choi did or didn't employ 3 individuals. The third, and that kind of leads on to the third point, which is that even if he weren't the premises licence holder, which isn't disputed, it's absolutely clear he was throughout the entire period for all 3 of the instances that have been referenced. It is open to the subcommittee to consider if he were a controlling mind behind the premises and the business, and the case law behind that assertion, which establishes that the particular point is Retro Bars Wales Limited against Bridgend County Borough Council, where a repeated change of the DPS was considered in that particular case, and ultimately the point being established is that if there is a controlling mind behind the business, the premises licence can still be accountable for, even if that person isn't the premises licence holder. In this case, Mr. Choi is the premises licence holder. I thought I would give that advice in open session so that all the parties can hear what I'm saying. I prefer to do that rather than when you're in private deliberation.
Absolutely. Very fair and transparent. Are you happy with that, Mr. Walsgrove?
Can I have a copy of the case? Because obviously it's important to understand the facts of that case. Whilst I'm familiar with its precedent, and obviously I endorse what Ben has advised you, just like the East Lindsey case that the Home Office has produced, which I was going to mention in my summing up, the facts of those particular cases can also have a bearing on why the judge came to the decision they did. So yes, about controlling mind, but there may... The strength of the evidence against that particular person may be entirely different, and so obviously I'd want to address you on the weight, which, as Ben rightly pointed out, in relation to the pace things, it's all about the weight of evidence. I've said myself, everything that's said is admissible. Unfortunately, in licensing proceedings, there's no rules of evidence to guide us. You can just say whatever you want, and you 3, unfortunately, have the unenviable task of having to attach weight to various things you've heard and then make findings for yourself. So if Ben, if I could just have 5 minutes just to refresh my memory of the facts of the case, I have no issue whatsoever with what he's advised.
Are you happy for me to finish this part and before summing up, and Ben sends over to you, then we'll adjourn before summing up?
Great.
Is that okay? I think that's just the way of getting through this part of it, and then by the time it's sent over, it'll all be over, and you can have a sit down and have a chat.
If I email that to you, would you have access to that on your phone?
Can we, alternatively, is there able to get a hard copy to...
I can't print it here and now. You could read it off my screen.
Okay, as long as you're happy with that, I should ensure that...
a bit longer on a phone, but it's fine.
Sorry, I'm sure you'll be fine. You've done it before. Do we have any more questions? No, okay. I'm going to hand over to the applicant for the review to ask any questions of Mr. Walsgrove. Do you have any questions for Mr. Walsgrove? Mr. Newcombe, do you have any questions for Mr. Walsgrove?
No, sir.
Thank you. I'm going to hand over to the responsible authorities. PC Vincent, do you have any questions?
Yeah, just one question for Mr. Walsgrove. He's quoted Hall and Woodhouse case, which I'm loosely familiar with in licensing terms. There is paragraph 20 of that, which says, if breaches do occur, the holder is liable for them, unless, having put in place an adequate system, he is able to avail himself of the defence of due diligence under section 139. What system was in place to avail the licence holder of the defence of due diligence under section 139? What measures did he have?
It does say that in that case, because that due diligence defence is available, but in relation to a business employing other people, that's not something which Mr. Choi can interfere in with someone else's business, or as the licence holder. That's what we say. You clearly say differently, but that's our position on that.
Yeah, I think it's just what measures had he put in place? Had he done any checks on the people that were taking over the business? Had he insisted on staff training records or anything like that?
No, just that obviously they would need to comply with any conditions on the premises licence, and it was for them to obviously put in place their own procedures for ensuring people were lawfully employed.
Thank you.
I mean, obviously, as far as running the premises is concerned, things like a challenge policy, etc., those were discussed with Mr. Lee to make sure, you know, he was going to comply with the licensing law, but there wasn't any due diligence about what HR systems Mr. Lee was going to put in place, and that's, you know, that's why we've suggested as a solution to this review to have the condition that no one else can use his licence ever again.
Any more questions? Acting Sergeant Rackham, any questions?
No, thank you, Councillor.
Okay. Do you have any questions from the line? No? Brilliant. We are going to go on to summing up, but as I've said, that we're going to have a small adjournment just so Mr. Walsgrove can have the familiarity with the case that was referenced from Ben Attrell, our legal advisor. Mr. Walsgrove, how long do you think you'll need? Half an hour? 20 minutes? Half an hour? We'll go 15 and everyone can go for a toilet break. Okay. We'll adjourn now and we'll go from when it's been sent. Okay. Thank you. Yeah, everyone's back. Brilliant. Thank you for coming back from the adjournment. Mr. Walsgrove, are you happy with the information provided?
Yeah, thank you, sir, and thank you for the time.
Okay.
So I can address it in my summing up. Thank you.
That's perfect. Obviously, I'm going to invite the applicant for the review to briefly summarise their case, if they so wish. So it's over to you to sum up.
Thank you, sir. It's quite clear that you've all read the papers extremely carefully and have taken on board everything that has been said by the various parties. Certainly, on that basis, I know that you have been given a full review of what the position is from the Home Office, so I'm not about to repeat it all. You've read it and you've got the papers in front of you. But essentially, the position is that on a balance of probabilities and given all the circumstances that have been considered in quite a lot of detail today, it is my position today that it's not the only course of action that you can take, but the only course of action which will be sufficient to justify what has happened would be a revocation of the licence. Mr. Choi has been given all the paperwork, and I fully take on board my learned friend's earlier comments with regards to the difficulty that he has had in communication with the legal department. I've taken a full note of that, and I can assure not only my learned friend but yourselves that that will be taken back. What they do with it is a matter for them, but I'm sure that if there is another submission made by my learned friend on another occasion that you hear, you'll know that something stronger than council going back and telling them that there was an issue. With regards to Mr. Choi, the positive is that the case against him was presented to him. He had all the paperwork that you have, and whilst, yes, the interviews are not full transcripts, as you've heard from the officer in the case, they are a summary of the salient points, and yes, what was picked out are the salient points. We work here, Mr. Choi is the boss, this is what I do here. Also in the paperwork are the interviews, so I'd ask you to consider those, and again the various submissions which have been put forward, which I won't repeat because I know they're in front of you, but unless there's anything I can assist the committee with, those are my submissions. Thank you.
That is fine. Ms Newcombe, do you have anything you want to add?
No, sir.
Thank you. I'm going to hand over to the responsible authorities who are submitting representations about it. Over to our friends from Hampshire Constabulary. PC Vincent, please.
Thank you, Councillor. There's been a lot of conjecture over who runs the premises and who's in charge of the premises, and it's a very confusing matter to try and decipher that. To simplify it, obviously Ben has earlier read out the paragraph 1126 of the guidance, which insinuates that if there is criminal activity at a premise, then the consideration should be for the licensing committee to take steps in relation to that. And if that nature is so serious that there is a certain criminal activity that may arise in connection with licensed premises which should be treated particularly seriously. A mention of that is the employing of a person who is disqualified from work by reason of their immigration status in the UK. Where reviews arise and licensing authorities determine that the crime prevention objective is being undermined through the premises being used to further crimes, it is expected that the revocation of a licence, even in the first instance, should be seriously considered. What I would ask today is if there is any ambiguity over who was in charge of the premises, whether it be the premises licence holder or the lease company, that you please give mind to that part of the guidance in relation to this matter. We have criminality at the location on 3 separate occasions, I know there's some ambiguity around dates, but we're saying 2011, 2012, and now 2021, where arrests have been made and offences have been committed, where illegal workers have been permitted by whoever to work at the premise. The guilt or innocence of Mr. Choi is not for us to decide. It's not something that we will decide today, but it does come down to, has criminal activity taken place at the Noble House restaurant? And the answer to that is a definitive yes.
Thank you, PC Vincent. Acting Sergeant Rackham, do you have anything you'd like to add?
No, thank you.
Thank you. Over to our licensed man, do you have anything? No. Okay. I'm going to hand it over to yourself, Mr. Walsgrove, to sum up.
I think just picking up on the last point from the police officer, looking at the criminality that's taken place at the premises, I would urge this committee to look forward in terms of, if you don't revoke the premises licence and you allow it to continue, is this likely to happen again? Because it is the only issue that has ever been raised about the premises, and I'm not suggesting for 1 minute it's not a serious issue. It is, and we understand that. But is it likely to happen again if you impose the conditions that we've put forward for you to impose? So having a licence for Mr. Choi where only he is allowed to use it for his business, and that is where the question of culpability comes in, because we say we have proved on the balance of probabilities that on each occasion it was not under his operational control. Your legal advisor referred you to that case, and I'm grateful for the use of his laptop during the adjournment, because it is important not to just provide one part of the ratio of that case, in that you can take into account whether there's a controlling mind behind the business. So on the evidence, we say there isn't a controlling mind anyway, because Mr. Choi hasn't got anything to do with Mr. Lee's business and the choice of who he employs. But in any event, the facts of those cases where that ratio came from were the director of the company who were applying for a premises licence had also named herself as the designated premises supervisor in the application. She was in fact a director of a company of another premises within that licensing authority's jurisdiction that had had its licence revoked. And on the evidence they'd found that that particular woman had clearly been dishonest, belligerent, and had answered questions untruthfully. So as I said, it's always important to have a look at the facts behind the judge's decision to find that her coercive behaviour, where on day one of the hearing for the application she was named as the designated premises supervisor and was a director of the company applying for the licence, on day two, when they realised that they weren't happy with her being the DPS, it was substituted for somebody else, a 21-year-old gentleman who, from what it says in the case, didn't have very much experience, and clearly they found that the lady who'd had a licence revoked and was the director of the company anyway was going to be effectively running it. Well, that isn't the situation you've got before you at all, because it's not Mr. Choi's company that were operating the restaurant when the illegal workers were employed, and it wasn't his decision to employ those two people. But accepting what the police officers have said about, well, crime has taken place at the premises, of course you want to be assured that if you allowed the licence to continue, that that isn't going to happen in the future by Mr. Choi. Because if he decided to lease the premises in the future, that person would have to apply for their own premises licence. They'd have to produce all their own due diligence and HR policies, because I now know it's a much more common occurrence for licensing committees to add conditions around illegal working, even though there is this existing statutory obligation, which is a fairly straightforward one, to make sure people are lawfully able to be employed. Licensing committees are imposing these sorts of conditions, the ones that I've proposed, as a matter of course, to make sure that people are complying with the law. So on all the evidence, as I say, on the basis of the burden of the balance of probabilities, we say we've adduced sufficient evidence to show he was not engaged in any criminal activity and had no involvement in it whatsoever, that the conditions that we've put forward will secure the future for this restaurant, and that there won't be any further issues with Mr. Choi in any question of whether he's being coercive or involvement, because if he's running the business, it will be under his licence. If he leases it to somebody else, they'll apply for their own licence. They'll have their own responsibility. And in my respectful submission, if a third party comes along and they've got, not saying Mr. Lee will come back, but third party comes back, gets a new premises licence, if they employed an illegal worker and my friends applied to revoke it, it shouldn't have any impact on Mr. Choi whatsoever. So if that licence was then revoked, he should then be able to use his licence because he's got his policies in place and he has conducted himself lawfully. The reality of the situation I've just described with the conditions is what it was before anyway. It's just we are now putting it into a format which everybody is clear about and which new business operators to Noble House would be clear about too. So I ask you to deal with the review in that way on the basis that that is the just, reasonable and proportionate response to the cause identified in the review. I'm grateful for the time you've taken to listen to the application.
Thank you, Mr. Walsgrove. I think that was a comprehensive summary. I'm just going to ask, I'm going to go around the table and just ask all the parties that they're satisfied with, they've said everything they wish to. So, as the applicant, are you satisfied that you've said everything that you wish to say?
Yes, thank you, sir.
Okay. Over to the responsible authorities. Are you satisfied that you've said everything you wish to say?
Yes, thank you, Councillor. Thank you, Councillor, yes.
Are you satisfied? He's nodding. Brilliant. And Mr. Walsgrove and Mr. Choi, are you satisfied that you've said everything that you need to say? And brilliant. Okay, we've got a nod. So now we are going to go into a closed session. So all persons except the subcommittee and our legal advisor and the person who records the minutes, which is over there. Can you all withdraw from the room, please? And the subcommittee will decide the matter in private. I'm just going to be conscious of the time. It's 3:30 now. I don't envision a decision within, what would you say, Ben?
This is not going to be a straightforward decision,
No.
whatever you decide to do. I think you can probably say 3/4 of an hour, perhaps.
I'm looking at longer.
Longer?
Yeah.
Well, if we say 3/4 of an hour, and then if the
I'd say an hour
parties can come back, and then we can give an indication at that stage. You can at least...
We'll say 4:30 and we'll give you an indication from then.
4:30? Okay.
Yeah, because it could be longer. Okay.
So the subcommittee will not reconvene before 4:30. You can go away safe in the knowledge.
We'll try and see that.
Anybody does happen to bump into any of the members whilst they might be going to the toilet or stretching their legs or smoking a cigarette or something, please do not talk to them. They will not talk to you. They're not being rude. It's just going to complicate things immeasurably if that kind of thing happens. Thank you.
Thank you. You can go and grab a coffee. but I'm only standing because it's easier to read than decision notes from my screen. So we are back from our deliberations and we've reached a committee decision in the matter of the Licensing Act 2003 application for review of a premises licence, Noble House Restaurant, 43 Osborne Road, Southsea, PO5 3LS. All parties shall receive a written confirmation of the decision and the reasons. Decision. The subcommittee has considered very carefully the application for review of a premises licence at the Noble House Restaurant. It gave due regard to the Licensing Act 2003, the licensing objectives, the statutory guidance and the adopted statement of licensing policy. The subcommittee considered the relevant representations, both written and given orally at the hearing by all parties. Human rights legislation and the public sector equality duty has been borne in mind while making the decision. The subcommittee noted that the application was made by the Home Office, citing the prevention of crime and disorder as the relevant licensing objective. The issues raised relate to the repeated use of the premises for an employment of legal workers. Representations in support of the premises licence holder have been received from residents, businesses and councillors. The police had submitted a representation supporting the Home Office request for revocation of the premises licence on the basis of the prevention of crime and disorder. The solicitor for the premises licence holder had submitted written representations in advance and these were expanded upon at the hearing. There were also an exchange of documents relating to the previous civil penalty notices and company documentation. After having heard all of the above evidence and considering all of the options set out within the legislation, ranging from taking no action to revocation of the premises licence, the subcommittee determined that the premises licence should be revoked. The reasons. Amongst arguments raised for the premises licence holder, the following were stated. Mr. Choi did not employ the 3 persons detained on the 23rd of October 2021. Mr. Choi has not been issued a civil penalty in the latest instance or previously. Also, no company over which he has a control has ever been issued a civil penalty notice. Mr. Choi had no knowledge of the employment of legal workers on any of the dates concerned. Mr. Choi had leased the premises to a third party on each of the 3 occasions. Mr. Choi and his business had suffered as a result of the proceedings. Mr. Choi denied that the behaviour was obstructive. Mr. Choi had arranged accommodation but had no knowledge of the employment of illegal workers. CCTV training and conditions would prevent third parties from employing illegal workers in the future. The subcommittee considered carefully all the points raised for the premises licence holder. It is not accepted that there was a degree of separation from the premises as set out in the case of Hall Woodhouse, where the company owned approximately 250 premises and let 2/3 of those premises by tenancy agreement, thereby having no day-to-day or direct control of those premises. The case cited concerned criminal liability for an offence under the Licensing Act 2003. The determination that the actions of a third party cannot necessarily make the licence holder liable to criminal prosecution is not applicable to the consideration of whether a licence holder is ultimately responsible for their licensed premises for the purpose of review. The circumstances of this review is not a position where, for example, a shadow licence was in force. Any other interpretation would go against the spirit of the Act and the statutory guidance which states 10.28, however, the designated premises supervisor and the premises licence holder remain responsible for the premises at all times, including compliance with the terms of the 2003 Act and conditions attached to the premises licence to promote the licensing objectives. 10.35. Similarly, the premises licence holder remains responsible for ensuring that licensing law and licensing conditions are observed at the premises. In any event that there are repeated breaches of the Licence Act 2003 or offences linked to the premises and the premises licence holder fails to act to address them, then ultimately the premises licence holder must always be liable to sanction, no matter how far removed from the day-to-day operation. In this case, it is incredulous to suggest that Mr. Choi knew nothing of the employment of those he had arranged accommodation for when they were clearly working in his presence at the premises at the time of inspection. The subcommittee noted that the workers and Mr. Choi were not cautioned before being interviewed, as might be expected for a criminal investigation. However, that failing in the respect of a criminal investigation is not relevant to the admissibility of the evidence before the subcommittee, nor does it significantly diminish the weight the subcommittee attaches to the evidence, which was contemporaneous with Mr. Choi stating at the time that in relation to the restaurant he was a director of the company and that he had undertaken checks, requesting copies of papers and passports, expressing knowledge of pay, working hours and duties, and in conclusion stating that he employs them as kitchen workers. Notwithstanding, the above subcommittee understands that the difference between an interview under caution and less formal questioning. it is not accepted that the prevention of a crime objective is not engaged in this case. The statutory guidance states 2.6, the prevention of crime includes the prevention of immigration crime, including the prevention of illegal working in licensed premises. It is advanced for the premises licence holder that it would be wrong to conclude that a criminal offence had taken place if that conclusion relied upon evidence that might be excluded at criminal trial. Even if that were the case, i.e. the evidence would necessarily be excluded, the argument is contrary to the principles established in licensing law that offences need not to be proven, or indeed proceedings not need to be commenced for the behaviour to be taken into consideration. See, for example, the case of Leeds City Council versus Sustain, rotating to taxi drivers, as well as the case referenced in the review application pack, East Lindsey District Council versus Hanaff. The point misses the fact that the licensing objective relates to the prevention of crime and disorder, and therefore must have a wider interpretation to include the consideration of behaviours that might fall short of conviction, or even the commencement of criminal proceedings. On the balance of evidence presented to the subcommittee, was satisfied that Mr. Choi was obstructive at the time of the latest inspection, was clearly aware of the employment of illegal workers at the premises. The accounts of those present at the time make it clear that he remained in a position of control in relation to the business, instructing them not to engage with officers attending. The representations for the premises licence holder asserts that the subcommittee must establish on the balance of probabilities whether Mr. Choi employed the 3 persons alleged to be illegal workers. The subcommittee has considered this point and would state that in order for the prevention of crime and disorder objective to be engaged, sufficient to warrant action to uphold its aims is a far wider discretion. This is confirmed by the guidance at paragraph 11.28, referenced by the legal advisor during the hearing, which states that where the authority determines that the crime prevention objective is being undermined through the premises being used to further crimes, it is expected that revocation shall follow. Clearly, it is the use of the premises, not necessarily a strict determination of the licence holder's actions, that is relevant. In this circumstances of this case, it is clear that Mr. Choi was the premises licence holder for the premises on the 2 previous occasions when illegal workers have been found working at the premises and arrests were made. On the latest occasion, it is absolutely clear that not only was he the premises licence holder, but he was also on the premises, was aware of their presence, and was exerting control over the illegal workers. The subcommittee is not convinced or persuaded that the lease of the premises or previous alleged leases were bona fide arm's length transactions, and are satisfied that he remained a controlling force. That a premises can be affected by someone other than the person nominated for a controlling position, and that action can be taken in those circumstances, is established by the Retro Bars Wales Limited versus Bridgend County Borough Council. In any event, in this case, Mr. Choi, and he cannot escape the fact, is the premises licence holder and was for the entirety of the relevant period. It is clear that there is considerable support for Mr. Choi and that he has had considerable experience in the licensed trade, free of conviction. However, the statutory guidance as referenced in the committee report is clear that this type of criminal activity should be treated particularly seriously, paragraph 11.27, and the authority has a duty to take steps to prevent illegal working in the interests of the wider community and not of those of the individual licence holder, paragraph 11.26. Further, that revocation should be seriously considered even in the first instance, paragraph 11.28. The police have expressed support for revocation of the licence, and in accordance with paragraph 9.12 of the statutory guidance, the licensing authority makes it clear that they should be the main source of advice on matters relating to the prevention of crime and disorder objective. The police also raised concerns regarding human trafficking and modern slavery at the premises. In their view, no conditions could be imposed to address the impact upon the relevant licensing objective. There is a right of appeal for all parties to the magistrate court within 21 days of the formal notification of the decision. The decision has no effect until the expiry of the appeal period or, if lodged, the determination of any appeal. That concludes today's hearing. Thank you.